Senate Judiciary and Public Safety Committee. Today's date is Friday, March 12th, 2021. We have 4 bills on our agenda today. Senator Chamberlain's bill is last on our agenda. That's the Veterans Restorative Justice bill that we've talked about for a number of months. He'll be able to join us at 11 o'clock. And so we're going to focus on the first 3 bills this morning. So to begin, Senator Ingebrigtsen has the first bill, Senate File 641, and I might mention we do have quorum as of now. Senator Ingebrigtsen.
Thank you, Mr. Chair and members. Senate File 641 I'm bringing before you is labeled as the Correctional Officers Discipline Provision Modifications. Mr. Chair, I do have an amendment. If you'd like me to offer that to get the bill in order. It's not a delete all, but it is an amendment. And maybe staff.
I believe, Senator Ingebrigtsen, you might have 2 amendments.
Yeah, probably do. Yeah.
Let's take the A1 amendment first.
Sure. And
this is original jurisdiction, so this is an author's amendment, putting it in the form he wants to present it. All those in favor say aye.
Aye.
Aye. Opposed?
Aye.
Sarah Bigham, you're opposing the bill or amendment?
Nope, I support Ingebrigtsen's amendment.
All right, just want to make sure. Your voice is very important to our committee. Let's do that again. All those in favor of the A1 amendment signify by saying aye.
Aye.
Opposed?
Aye.
She must be a little behind us there on the technology or something.
Yeah, opposed. Nevertheless, the amendment is adopted. And Senator Ingebrigtsen, you have the A2 amendment as well. Author's amendment, it looks like it's just a 2-word change.
Mr.
I think
Chair,
that would be a technical amendment.
Sure. If I can incorporate that, maybe staff can explain that one. I don't have it handy with me right now, but.
All right. Council, would you want to weigh in and explain the A2 amendment?
Yes, Mr. Chair, members, the A2 amendment essentially is a continuation of the A1. The A1 that you adopted takes state correctional officers out of the bill. This amendment, the A2, should have been part of the A1, but we caught it at a later moment. So it just continues that. It's technical compared to the, fully effectuating the A1 amendment.
All right. We have the A2 author's amendment before us. All those in favor signify by saying aye.
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 Opposed? The amendment is adopted. Senator Ingebrigtsen, you can explain your bill now.
Mr. Chair, and I do have a testifier, but I'll start out by saying that the bill addresses disciplinary procedures involving correctional officers. It places correctional officers under the same procedural fairness rule as peace officers. Presently, there are 2 statutes regarding these regulating these procedures. The correctional officer statute only addresses about 1/3 of the issues addressed in the peace officer statute. Since peace officers and correctional officers often face the same situations with the same requirements, there is no reason to have a different set of procedural requirements for their internal disciplinary procedures. The procedures involved in these statutes do not include criminal investigations. The amendment removes state employees upon request of the commissioner. The commissioner said we had conversations with Commissioner Snell, and he said they had a very good system in place in the state corrections. So that's been removed with the amendment. I have not been aware of any opposition to this bill. And with me today, I do have Adam Burnside from the Law Enforcement Labor Services, LELS, for him to testify if you have any questions.
All right. Mr. Burnside, welcome to
Yes.
the committee.
Thank you,
Would
Chair.
would you identify yourself for the record and then proceed with your testimony?
Yes, thank you, Chair and Senators. My name is Adam Burnside. I'm a business agent with Law Enforcement Labor Services. We are the largest law enforcement union in Minnesota, representing over 6,000 police officers, deputies, correction officers, 911 dispatchers, firefighters, medical examiners around the state of Minnesota. And I'm here to testify on Senator Ingebrigtsen's bill to incorporate the Corrections Officers Procedures Act into the the Peace Officers Discipline Procedures Act.
And could you proceed with your testimony?
I will. Thank you, Mr. Chair. So when a licensed police officer, a peace officer, a police officer, or a deputy has a complaint lodged against them, either from the public or from their chief law enforcement officer, the sheriff, the chief, what have you, they're afforded certain due process protections under the Police Officers Discipline Procedures Act. And there's a whole litany of things, but the big items are that the officer is given a written summary of the allegations against them prior to being questioned about the matter. The statement date and time is during their normal work hours. We know that law enforcement officers and correction officers work a 24/7 schedule. So necessarily, sometime officers come in, are night officers, and they have to come in, either come in during the day to be questioned, or the interview happens at night during their regular work hours. Also, they have a right to representation, either having an attorney present, or they have a right to have one of their union officials, a union attorney, a union business agent, maybe their local president, present during the interview or the statement. And also, there's a mechanism to hold the employer accountable for violating the officer's due process rights. So if a police officer isn't given a summary of the allegations, or they're denied representation during their interview, there's a mechanism in place to hold the employer accountable. And that mechanism works because we don't see, hardly ever do we see violations of the Peace Officers Discipline Procedures Act. And what this bill does is affords to correction officers those same due process. Now, the Correction Officers Discipline Procedures Act does provide certain items, but the big ones that I mentioned previously are ones that are not. They don't get, they're not afforded the written summary. They're not required to be interviewed during their regular work time, or compensated if it's during their off-duty time. They don't have a right to representation. So under the Correction Officers Discipline Procedures Act, they can be brought in and questioned without any knowledge of what the allegation is before the door is closed. They can be denied representation. And there's no mechanism to hold the employer accountable if there's any certain violations of the few rights that they do have under the Corrections Officers Discipline Procedures Act. And so we're just looking at bringing those, we'd like to see those brought in line. I deal on a daily basis with correction officers, and, in the course of the job, allegations are made, misconduct allegations, and we're just looking to afford them the same due process rights. These aren't criminal investigations. These are just simply workplace job duty investigations. And the reality is many counties do actually choose to treat correction officers and dispatchers, for that matter, the same as police officers or deputies. Stearns County, Carleton County, Ramsey County are a few examples where they just have one procedure that is based off of the Peace Officers Discipline Procedures Act, because I think it's easier to have one procedure than to have different procedures depending on what law enforcement entity you're dealing with within the county or the city. So, I mean, that's the brunt of my testimony. We're looking just to see that the correction officers treated similar because of the similar duties and responsibilities that they have, and really the similarities in the allegations that you find in complaints against them.
Right. Senator Ingebrigtsen, I believe you have another testifier.
I'm not sure of that.
Well, let's put it another way. There is another testifier who wishes to
I
speak.
believe Court Holton, I believe is that who?
Well, we're going to go with Mr. Brett Onstad first.
All right. Okay.
Mr. Onstad, I hope I'm pronouncing your name correctly.
Yes, very, very close. My name is Brett Onstad. I'm a correctional officer at Ramsey County, and I'd like to add to what Mr. Burnside said. First, thanks for having me here today. I'm a correctional officer with Ramsey County at the correctional facility, which is located out in Maplewood. Been a steward for 20 years. I'm also a trustee with the Teamsters. Correctional officers at our facility are not given any kind of advanced warning if they're going to be investigated. I often have to defend people who are called in the middle of their shift or told to come in, on a midnight shift. Maybe they come in early for the convenience of management to be able to testify on a case, and I'm not told why they're being brought in until they're actually being investigated. And I know myself, I've been investigated where I was not told the reason why until I'm actually having to testify. This is scary for our officers because they don't know why they're being investigated, and they're defending their job without any kind of advance warning or ability to know the charges against them. And but Mr. Burnside did make some very valid points, and I appreciate his comments. And with that, I would stand for questions.
Thank you, Mr. Onstad. We'll now move on to, is it Mr. Court Holton, Senator Ingebrigtsen, or is there someone else from his office?
Mr. Chair, I did have that name on my list here. I'm not sure who's here. I don't know if he's here or not.
Is Nancy? No. She's not here either. So I think that's the end of our testifiers, Senator. We can open it up for questions now. Senator Pappas.
Thank you, Mr. Chair. Mr. Onstad mentioned he was from Ramsey County. And I think that Mr. Burnside said that Ramsey County was one of the counties that already uses this approach with their correctional officers. So I'm just wondering why there was a difference in testimony.
Would our previous testifiers be able to answer that question, Mr. Burnside?
Yeah, I will defer to Correction Officer Onstad. I may have been given incorrect information. I don't personally represent the Ramsey County Correction Officers, but I thought I had heard from another business agent that they did. So we can definitely correct that testimony. I'll definitely defer to Mr. Onstad since he has firsthand knowledge of what happens in Ramsey County. And I apologize for that incorrect information.
Mr. Onstad, can you deliver some light to this?
The one thing I can think of was we have two correctional facilities in Ramsey County. One is the jail that's run by the sheriff, and then the correctional facility in Maplewood is the Ramsey County Correctional Facility, is a community corrections program. And I believe that they're both being done the same, but I can't say for sure what's happening with the sheriff's office. But it might be more tied in with the sheriff, that they may have slightly different procedures. But I can say for myself that my experience is that it's in fact, last week I had someone that had to go in to defend themselves without any prior knowledge of what they were defending themselves for.
Senator Pappas, any further questions?
No, I just was curious about that. Thank you, Mr. Chair.
Good question. Senator Bigham.
Thank you, Mr. Chair. And you are correct. I'm having a little bit of internet problems where I'm at. I just want to, I guess, ask the question, Senator Ingebrigtsen, maybe. You and I together have passed this bill, I think, every session for the last three, whether it's been in Chair Limmer's omnibus bill or as a standalone. And I'm glad that you amended out the state correctional guards, because they have repeatedly asked that they not be included in this. And so I'm wondering, how is this bill different than the one that we have passed each of the last 3 sessions? And it just appears that kind of the normal stakeholders, Teamsters, AFSCME, those guys are not here. So I guess I'm confused at what the difference is between the 2 bills. If you could allude to that. They passed unanimously, so I don't think there's controversy, but I'm just wondering why is there a difference this time around?
Senator Ingebrigtsen?
Well, Mr. Chair and Senator Bingham, I'm not sure, quite frankly, other than the fact that I know that it's a pretty big amendment to get the state of Minnesota correctional officers off of there. Up until just recently, I wasn't aware that, and maybe you were, I wasn't aware that Commissioner Schnell was concerned about the state and that they had a very good situation going on with their employees. I have not heard from them, their representation as to, their union leader or whatever representative speaking against this either. So apparently they have something that's in pretty good condition. I can't answer that unless staff can remember something like this that could answer your question, Senator Bingham.
Perhaps
Well,
perhaps we can ask council if they might have a remembrance of this. Maybe it could help your answer, Senator Bingham.
Yeah, and Mr. Chair, just to be clear, I know AFSCME supports your amendment. I mean, I'm not saying there's any opposition to it, but I'm just curious as to, it seems like this is a different approach to how we've done it in the past for that it's passed unanimously in obviously a bipartisan manner. But my other point is I think that when you're looking at state correctional and local correctional, I think there are different processes. But also, I think because you're dealing with different inmate folks, and then also I think it's different than a sheriff or a rank and file cop. So, and I'm just hopeful that we're going to continue to have this discussion, and that it really doesn't impact any sort of collective bargaining. It doesn't impact any sort of worker rights, because I think that's what you're trying to do here, Chair Ingebrigtsen. So let's just, I just find it was a little bit of a different approach. And so, but yeah, if council would want to kind of elaborate between the different approach or the rationale for that would be helpful if they can. Otherwise, Senator Ingebrigtsen and I can follow up.
Mr. Backus?
Yeah, thank you, Mr. Chair, members. I don't have information on all of the times that the Senate has addressed this, but I believe the last time was 2019. The Senate passed Senate File 2188. That addressed this issue by putting local correctional officers, it codified a brand new section of law in Chapter 641 that when I looked at it, it looked like it has most of the changes being made this time. This time it's a different approach in that it puts it in the Chapter 626 provision, which already exists for peace officers. The main difference between the 2019 bill and this one as amended, I believe, is this one has the cause of action if the government violates the terms of the act, where the 2019 version I don't think had that. So I think that's the main substantive difference that I could say.
My conversation with those in the Department of Corrections regarding state correctional officers to be included or not, this amendment, I believe, was in response to the commissioner not wanting his officers to be included in this bill. I had discussion with rank and file COs. They did not state that they were opposed to it. So I don't know why or what the reasoning is from the Department of Correction commissioner. but nevertheless, we have the bill before us. Senator Ingebrigtsen, do you know why state correction officers are not, the real reason why they're not simply beyond the request of the commissioner?
No, I don't. I guess what I took from the conversation that I have had with the commissioner is that they have a very good process in place now. And without hearing from the representation from the correctional officers, I'm assuming, and maybe I shouldn't, but I'm assuming that they're okay with what they have. So, Senator Bigham talked about they have different clientele that they deal with. Really, not so much. But yes, in fact, I will certainly recognize that you do have probably more folks that are a little more, potentially a little more violent or more complaintive against the individuals that are working in there. But kind of those complaints are somewhat all the same. In my experience, the folks that have plenty of time to sit around and figure out what they can do next when they're being confined, it's kind of interesting, to say the least. And so the jailer, I call him jailer or corrections officer, is always under the thumb, and some of the complaints are really really kind of funny. And I should never say a waste of time, but at the very least, before they get called before the sheriff or the jail administrator, they should know what the complaint is, so that at least can compare in their own, prepare for their own defense, if you will, or they'll know something about the allegation going into the office. So it just seems really fair to me, and I know the sheriff support this, and the correctional officers certainly do.
Thank you. Senator Kiffmeyer.
Thank you, Mr. Chair.
There you go.
Yeah. Thank you, Mr. Chair. I'm just a bit baffled. It seems like this is such a common sense fairness issue for people to have this kind of a process. So I'm really puzzled as to why this can't get through and being passed or signed into law. So maybe I just don't understand it. And so there must be something, somebody or someplace that is really fighting against this, because it just seems too obvious. Can anybody address, it's hard to say the why question, Mr. Chair, because, but something's holding it up or making it sticky. Maybe Mr. Backus can add some depth of understanding to that.
Mr. Chair?
Senator Ingebrigtsen.
If I can, Senator Kiffmeyer, that's a very good question, and I've lived through this whole process for the 30-some years that I was there, and there was always a difference, or at least there was perceived a difference between jailer dispatchers and licensed peace officers, and I think that's where it actually is. One is licensed and the other are not. However, the allegations really don't seem to matter. I mean, that doesn't matter. It's going to be a county or a city or a correction agency's responsibility to take care of the complaint under the human rights violations and whatnot. So I think it's just something that's been needed for a long time. I don't see it having any problem at all making passing the muster. I know Senator Bigham has worked on this a long time, and this is I think this is really good stuff, and everybody seems to agree.
Well, Mr. Chair.
Senator Kiffmeyer.
So the obvious question then, is it also moving in the House? I mean, is this something that's an orphan in the Senate? But where are we at with it in the House? Because practically speaking, it needs to be in both to get done and accepted in both.
Yeah.
Senator Ingebrigtsen.
And I apologize, Senator. I don't know that. I can let you know offline, but I simply don't have access to that right now. Or even who the other. I'm sure there's an author over there. The Senator Bigham may be able to answer this. I don't know.
Right.
I believe Representative Wogelmott, if I'm pronouncing that correct, has the bill.
Yeah, that's my understanding too, is Representative Dan Wogelmott has the bill.
Right.
Senator Bigham, you can't give us any insight as to whether Representative Wogelmott, thank you, Mr. Chair, that it's going to be acted upon in the House with Representative Wogelmott?
Mr. Chair and Senator Kiffmeyer, no, I don't. I'm house trained, but I don't. I haven't had any conversations with them about how the bill is proceeding. But Senator Limmer has been in the conference committees when we used to have them, so maybe he has insight as to why it's taken. Like I said, I think every session I've been here, which this is my 4th, I've been involved in this. So I don't know why it doesn't get across the finish line.
Well, Mr. Chair, maybe our testifiers can help.
Yeah, that was what I was going to suggest. Mr. Burnside would probably understand that. He's following it.
Mr. Burnside or Officer Onstad?
I wish I had insight in, Mr. Chair.
Right.
I wish I had some insight into why this bill has stalled and where the opposition lies.
Well, why don't we do our part as a Senate and advance the bill? I just had one quick question to Officer Onstad. Officer, you made mention that you've seen a history of no advance warning when it comes to some type of hearing of an officer based on an accusation or a disciplinary action. And that would mean that you have no prep for the officer to prepare for any questioning. At that point, is there a union representative with that officer, or is that denied also?
They do get a union representative, and typically it's me. I get to go in
and then
with the officer. Go ahead.
And then is the union steward or the union representative, are they informed in advance of what the subject's about?
Not much more than the officer that's being accused. I might get a warning just saying, hey, we're going to talk to the officer about this, but they've told me do not tell the officer until he gets down. They've directed me not to inform the officer so that they can get what they call an honest and fair opinion. But to me, it's not, because when you're under the gun and you're thinking, could I get fired for something like this? It's very stressful and can lead to bad answers.
Yeah, I think we've heard enough on discussion. Senator Ingebrigtsen, pardon me. Would you move your bill?
Mr. Chair, I would move Senate File 641 as amended to pass and
move to general orders.
Go to general orders.
All right, the motion is before us. Hearing no further discussion. Members, please open up your mics and screens. All those in favor signify by saying aye.
Aye.
Opposed? The motion prevails. Thank you to everyone and Senator Ingebrigtsen. We'll now move on to our second bill. Oh, we still have Senator Ingebrigtsen in front of us.
We're right here. We're taking care of all the state business today, Mr. Chair.
Well, I don't know how the state
can do it without us.
Continued without you, Senator Ingebrigtsen. Senate File 611.
Mr. Chair, I'll take that as a compliment. Senate File 611, members, is a bill that I've had for a couple of years and been working on it with the parties, and we have testifiers here today. Mr. Berry, who has a real personal experience with what we're talking about, and we have Jeff, I want to say Nakamar from Policy Director from the Minnesota Brain Injury Alliance in here today. So the gist of the bill, and I believe I do have an A1 delete all amendment.
Yes, this is an author's amendment and putting it in the bill form that the author requests. The bill is before us, the A1. Members, open your mics. All those in favor signify by saying aye.
Aye.
Aye. Opposed? The motion or the amendment is adopted. Senator Ingebrigtsen.
Thank you, Mr. Chair, and staff could jump in if they'd like, but the amendment, basically the A1 amendment just puts, as you notice at the bottom of the bottom of the second page, section 2 is an appropriation, an open-ended appropriation here, not filled in. And I'll have Mr. Turner talk about that. But what the gist of the bill is, and then I'm going to let the testifiers come in if I could, and because they're going to be able to explain it much better than I. But we feel that there's some people are getting lost in the system due to traumatic brain injury, whether it be from a stroke or fetal alcohol spectrum disorder. The court may want to order, should be ordering a neuropsychological examination, and that's what this is about. This is kind of a big step, I think, for the court systems, and I say a big step in that financially it is. However, when you talk about individuals that are suffering from these, these diagnoses, and they get imprisoned, a lot of different things happen to them, and they don't do well there, and sometimes I think the term getting lost in the system at best is what happens to them. They get taken advantage of, and I'll let Mr. Berry talk about that. But and I don't know how you want to proceed, Mr. Chair. If you want the testifiers first, and then we'll talk about the financial aspects of it with staff.
All right. Why don't we go to our testifiers first, then we'll get to Mr. Turner regarding finance.
Thank you, Mr. Chair.
Mr. Jeff Nachbar. I see you now. Would you identify yourself for the record and then proceed with your testimony?
Thank you, Mr. Chair. Jeff Nachbar, Public Policy Director with the Minnesota Brain Injury Alliance. And thank you for the opportunity to testify in support of Senate File 611. I understand you have a very full agenda. I'll just make a few brief comments and stand by for any questions that people have. As Senator Ingebrigtsen mentioned, what we're trying to do is to break the cycle of in the criminal justice system and incarceration faced by people with brain injury, stroke, or fetal alcohol syndrome. The bill asks for neuropsychological examinations to be conducted and considered prior to sentencing for people convicted of a felony with brain injury, with a history of brain injury, stroke, or fetal alcohol syndrome. As this bill's progressed over the last few years, and we hoped to be in here last year at this time, but obviously COVID stopped us in our tracks. But as the bill's progressed, what we've really been doing is balancing the cost of conducting these exams with getting the biggest sort of bang for the buck in terms of who's most directly negatively impacted by this. In other words, who's the most vulnerable that are at the greatest risk within our current system. And as we continue to balance that sort of cost with the how do we affect it and sort of try to thread the needle on how to make the biggest difference and impact the most folks' lives. Obviously, it's not, or maybe it's not obvious, it's not a get out of jail free card. It's asking that this information be taken into consideration. Another thing that you'll see too is that we're not looking for an unfunded mandate on the counties. We want to address the costs as we move this bill forward, because what we're really ultimately looking for is the savings that we can capture from keeping people from a lifetime of incarceration and that are caught up in the system, and how we can, I'm sure you guys see this every day, the challenge of our state budget system and looking at short-term costs versus looking at the long-term costs. So how do we make sure that we address the most vulnerable population, have the biggest impact on those folks' lives, get them out of the system? I've talked to many of you about this, so I don't think I need to go on any further than that out of respect for your time. I'm sure you'd like to hear from Tim Berry, who was directly impacted by this and his family, and I'm happy to answer any questions that you might have. I'll stand by. Thank you, Mr. Chair.
Thank you, Mr. Nachbar. And next will be Mr. Tim Berry.
Thank you, Mr. Chair and Senators. I appreciate your time this morning.
Would you identify yourself for the record? And that
Tim Berry from Vertus, Minnesota.
All right, thank you. Please proceed.
I want to thank each and every one of you. This is my daughter, Cassandra. This is who we're talking about. That's my daughter. The treatment of the mentally ill in our state is and of itself a crime. This from a sergeant at the Crow Wing County Jail. The Department of Human Services just slams the door on us. This from the Minnesota Sheriff's Association. Tim, I know your daughter fell through our safety net. My response, what safety net? Commissioner at the Department of Human Services, I know, Tim, there is none. Tim, your daughter is the poster child for a broken system, a DHS employee. Commissioner Paul Schnell went out and visited my daughter at Shakopee, where she sits now. He came back to me and said, Tim, what is your daughter doing in my prison? Representative Jack Considine went out and visited my daughter at Shakopee. He come back and he said, why is this girl in prison? What's a father to do after hearing these things from a system which I thought was designed to protect the vulnerable in our society? These are just a few of the things I have heard over the last 7 years trying to get my daughter help in our state. Cassidy's story, bipolar at 15, which turned into addiction, self-medication. At age 26, had a massive frontal lobe stroke, traumatic brain injury, along with the amputation of her right leg due to the stroke. Since this time, I've been trying to get Cassie help wherever possible. Basically, the only place she has been is prison and jail, and maybe a treatment center that is not designed for stroke rehabilitation. When in prison, she received her prosthetic leg and began to walk. The inmates stole the remote control to her leg and flushed it down the toilet, leaving her leg inoperable. What damage did this do to her psyche? The prison sent the leg to Essentia Health for repair. Essentia Health repossessed my daughter's leg for non-payment because when you're incarcerated, Social Security disability will not cover. She lost her leg twice. What psychological damage did this do along with the stroke and the TBI? When she's in jail or prison because of her brain injury and lack of impulse control due to the stroke, she spends most of her time in solitary confinement. What further damage does this do? Cassie currently sits in Shakopee Women's Prison in solitary confinement and segregation. Why? Let me tell you. In August of 2018, she went to Tapestry, a dual diagnosis women's treatment center in St. Paul, where after a couple of weeks, her and her roommate got in an argument over a pillow. Cassie threatened to kick her with her one leg. They kicked my daughter out for the exact behavior that she was there to treat. She came back to Fergus, where probation and parole put out a warrant for her arrest for not completing treatment. She called the Fergus police to come and get her. By the time they got there, she had taken some of her medication and was out of it. They took her to Clay County Detox, where after 2 days, someone left the front door open. And my daughter, in her radiant wisdom, decided to wheel herself out. They found her across the street, wheeled her back in, and in the process, Cassie hit an orderly. They charged her with felony escape, 2 assault charges, and took her to the jail where she incurred 2 more assaults on correctional staff. She now sits where she sat with 5 charges. She now sits in the women's prison in Shakopee. This is but a minuscule part of Cassie's story, and I'm sure one that could be told by families across the state. From my perspective, if an individual citizen treated a vulnerable adult or mentally ill person the way the state treats them, they themselves would be in jail. Time has come for criminal justice and human services reform in our state so people and families can get the help they need and stop suffering. I would like to read you just a snippet out of Insane, America's Criminalization of Mental Illness. It is a source of great complaint with the sheriffs and jailers that they must receive such persons because they have found no suitable accommodations for them, wrote minister turned prison reform Reverend Louis DeWitt. Louis DeWitt wrote that in 1820. We are still locking up the mentally ill and now the brain injured. In a policy paper from the Supreme Court administrators, decriminalization of mental illness, fixing a broken system, put out by the Conference of State Supreme Court Administrators, would be an excellent start. When mental illness is a factor in lawlessness and that fact is ignored, the result can be unproductive recycling of the perpetrator through criminal justice system with dire consequences to us all. That is Chief Judge Judith S. Kay. I want to thank you guys. I could go on for hours. I've been fighting this for 7 years. I walked across the state 3 years ago to bring awareness to this. And we are finally making a little progress. I ask for your support. My daughter needs help. She don't need to be in solitary confinement in our women's prison. I thank you guys.
Thank you, Mr. Berry.
One more thing, sorry.
Yes, go ahead.
This is what we're talking about. Last time she was in court, I had to go get a neuropsychological exam for my daughter, which I paid for out of my own pocket. This is a doctor's opinion. Cassandra does have mental deficiencies from her stroke, but also from her history of seizures, migraine headaches, multiple concussive episodes, polysubstance abuse. Cassandra does not present an imminent risk of serious danger to another person, yet at the same time, it would also be fair to say that our ability to predict what would provoke Cassandra is not good, not as good as it would be in an individual with her type of stroke difficulties, and because of the lack of treatment she has had to adapt to her stroke symptoms. Treatment, to the best of my ability to determine, has not been consistently applied to this individual for many reasons, but nonetheless, there is treatments that could be attempted to assist Cassandra develop more control over her life. This is what we need in our court system. The Rule 21s, they do nothing. They are just a snippet of what is needed by people in our state. Thank you, guys.
Thank you, Mr. Berry. Questions, Senator Ingebrigtsen?
I have no questions. I'll save my words for my final comments if I can.
All right.
If there's other questions.
Mr. Berry was our last testifier, and we can open it up for questions or comments by our members. Senator Anderson.
Thank you, Mr. Chair. This has been, as Mr. Berry has already mentioned, an ongoing problem, an issue in this state, in this nation, for decades, maybe even centuries. And it's unfortunate that we haven't been able to have the intestinal fortitude as a legislature to come forward with some way to find a facility or facilities to help law enforcement arrange for these people to get help mentally, physically, to help not have to be locked up in a Shakopee or Oak Parks or wherever we've got them now. And I think that this is just a Band-Aid that we're doing, but it is a step. But you continue to put a Band-Aid on top of Band-Aid, all of a sudden it falls apart and you still have the wound left behind there. And so we've got to do something major than what we're doing right now. And I think we're just tipping around the open hole, the dark hole that many of our people in prison right now are suffering from, and that's mental health and also TBI. So I really think that there's been some attempts to go forward with legislation, but it's always been put back on the back burner and sometimes buried in our past. And we need to go back into our legislature, back in some of our past proposals for mental health facilities to help. Again, I'm repeating myself, but again, we need to help our law enforcement get a handle on these, because as much as we try to train our law enforcement people to recognize individuals that have this type of a situation, and then to continue to add more insult by more levels of crime against these individuals, we demean the human race, the individuals that are suffering from this. And so I thank you, Senator Ingebrigtsen, for bringing this forward, but we got a long ways to go.
Thank you, Senator Anderson. Senator Mark Johnson.
Thank you, Mr. Chair. Yeah, so this is something that I've been delving into a little bit more lately. There's a professor out there, Saplowski, who's an endocrinologist, who talks about this sort of thing, which is very, very interesting. You know, he talks a little bit about the structure of our brain and the frontal cortex, and how differences within that can really help explain some of our behavior. And when Mr. Berry was talking about the changes in his daughter's brain due to some of these injuries and situations that have happened, you know, it leads me to wonder exactly. So let's take this into account. Let's say that we take into account the traumatic brain injury, the stroke, but we could maybe even throw into that maybe the ACE score, which documents kind of the childhood trauma that changes the way the children's brains function. And then we start getting into the larger subject of, does our criminal justice system really address what's going on in meeting the needs of those individuals? So let's say that Mr. Berry's daughter, we did take into account initially those sorts of things, her stroke, her traumatic brain injury. What types of facilities, what types of things can we be doing that wouldn't necessarily put her into prison? Because, well, we're not trying to punish her necessarily. We're, you know, the fact that we can't rewire her brain, it's pretty doubtful. You know, is it a matter of restraint? Well, maybe prison isn't the type of restraint that we need for Miss Berry, and it's not maybe the most humane. So what's the alternative to prison if we do determine that the structure in her mind causes her not to have the free will to be able to control these sorts of things?
Are you directing that to anyone?
Anyone that can.
Kind of a rhetorical question, I'm sure. But do any of our guests have a suggestion, or Senator Ingebrigtsen? What would be the best alternative?
I'd like to have Mr. Berry answer that, and then I certainly would. I've got some ideas.
All right, Mr. Berry, what would be the best place for your daughter now?
Thank you, sir. Right now, my daughter needs stroke rehabilitation. She has never received the rehabilitation that she needs for her stroke. She has been sent to drug and alcohol treatment centers, which are not designed for stroke rehabilitation at all. And that's where she gets tripped up, because the effects of her stroke have not been addressed. And that's going on 7 years now. And adding to that all the time in solitary confinement, I can't imagine what damage that is doing as well. Hospitals, the problem is we have no more, we don't have beds in the state of Minnesota. They are backlogged. There are no beds for, you guys know the problem. The beds have been shut down, state hospitals shut down. That was a dire mistake in my thinking, but that's neither here nor there. My daughter needs stroke rehabilitation. And there are places designed for that. She has never been offered that. And I think that's what this neuropsychological exam, a judge could use that and have TBI victims sent to the proper rehabilitation center. That's what I see.
Thank you. Senator Ingebrigtsen, you wanted to add to that?
No, I think he could go on for hours, as he said, and Senator Johnson makes a good point. What do we do with them? Well, quite frankly, with the amount of injuries that Mr. Berry's daughter has sustained over the years, it's very clear that she's acting out, and our only resolve to that as a system in Minnesota is to charge her with another criminal offense and put her in another jail. And those jails receiving people with that kind of a condition kind of close their eyes and they go, oh my goodness, now what are we going to do? So they're not capable of doing that. This person obviously needs to be hospitalized. And Mr. Berry's right. We did close down the hospitals that did take care of them. We do have the CBHH hospitals throughout the state, but they're full. You know, that was our answer back then for mainstreaming folks that had problems. And, you know, we've had this discussion with Senator Senjum. He's put a lot of bonding money out there for more beds, for emergency services. But it's very clear that this type of a patient is not criminal. I mean, they just don't belong in jail. They need to get the rehabilitation and the help that they can. And if they can't get rehabbed, then they have to be put someplace that's under supervision. And looking through bars or that's just, it's almost inhumane. So I really have to give Mr. Berry credit for the amount of time and effort that he's gone through for his daughter. It's just been countless hours. I see him a lot, and maybe several of us have seen him a lot, and he is just he's on a mission. And I think hopefully this is a step in the right direction, Mr. Chair. And when we talk about funding, certainly these things, these examinations are very expensive, and maybe we should probably talk when the other ones are done here to Mr. Turner as to the cost factor here, and I guess when do we start considering the humanity part of cost? I guess we're all going to have to decide that, what it's going to take. So,
thank you, Senator. Senator Johnson, do you have any other questions?
No, Mr. Chair. I support the bill, and I think we need to look more into what's going on in individuals' lives. But I'm still a little disappointed that what is a judge at this point? Let's say they determine that there are some of these factors. It seems to me that there is really no alternative at the moment, the way the structure is set up, for that determination to really make a difference in where an individual is going to be spending their nights and days. So that's all I wanted to bring up. Thank you very much.
Thank you. Senator Kiffmeyer.
Thank you, Mr. Chair. So here's one of the things that I think when you talk about the cost of the neuro evaluation and funding that, most of these folks are on MA, medical assistance. If they are, the cost of that assessment should be covered, or they should be directed to cover through medical assistance. And so I don't know if we're taking on in the justice system an actual healthcare expense. And so Senator Ingebrigtsen, I'm not sure if you have considered that, because this is going through Judiciary and being treated as a criminal justice system issue, but it's really a healthcare issue. And so the resolution of this and some of these things, and this might be a good area for a diversion kind of treatment, but we keep coming into these where we have a criminal justice system trying to do this healthcare. And that's recognizing there are very big limits. And if someone with a mental health issue commits a felony and a crime, what do we do in that? I mean, you also have to deal with the crime itself, but there are mitigating circumstances, which I think is what Mr. Berry and Senator Ingebrigtsen, your bill is trying to do. But as to the cost, when it's a healthcare cost, has this gone through that kind of concept of medical assistance? Maybe they're on MNsure, should be picking up these sorts of costs, not the criminal justice system.
Oh, Mr. Chair.
Senator Ingebrigtsen.
Mr. Chair, I think that's exactly where we're at right now. Here is who pays for this, and it is very expensive. But I would tell you that at least my feeling is that if you're on medical assistance, which I think some of them are, if you have a broken leg, you go in and get it fixed. This should be really treated no different. This is actually going to lead to a lot more expense. I think, as the other testifier, Mr. Nachbar, had said, is, you know, some investments in these kind of determinations and putting these people in places that are not going to continue to go through the court system. And that's why we're kind of conflicted here. We deal with the court system, and that's what this bill does. It orders the judge to do this. And after it's found out that they do have this traumatic brain injury and they need medical help. They don't need jail help. They don't need incarceration. That's not going to do it. Then they have to be hospitalized. They have to go someplace. It just seems.
Well, Mr. Chair,
and you're right. Why are we here? Well, we're here because it's still being handled here.
Senator Kiffmeyer.
Yeah, thank you, Mr. Chair. It seems as though our fear of the institutions, which were so badly done many years ago, blinds us sometimes to the practical reality that when you have circumstances like this, you need a variety of security, services, protection, and all of that, which I think Senator Senja might have had a bill to do something like that, to have these places. But I think it is important, but I think sometimes our fear of that just blinds us to the practical reality of settings where you put services for folks that have this kind of special need that also would include some security as well. But sometimes in this language, I've seen it in HHS bills where you say, shall seek reimbursement from any insurance provider for this first before going to the criminal justice payment process. And that might help in the fiscal note as well. Just a thought.
Why don't we ask Mr. Turner to weigh in here? Because there is a financial open line. Mr. Turner, could you give us any perspective on the fiscal angle on this bill?
Yes, Mr. Chairman, members. A revised fiscal note has been requested on the A1. There was a note on the original bill that said there was no state impact. The problem with that is that the counties, not the state, are responsible for pre-sentence investigation costs. And so to address that, the A1 amendment has a blank appropriation to the courts for reimbursement of those exam costs. Hopefully by the time the bill gets to the Finance Committee and we have the revised fiscal note, we'll have worked out two things. Well, first of all, that the reimbursement appropriation will be in place. And then second, we'll determine exactly how many of these exams are going to be necessary. That's a big question because they run, the estimates are from $2,000 to $3,000 a piece. So hopefully by the time we get to finance, I will talk to the courts and MMB, and we'll come up with some sort of number to address that.
Mr. Chairman, could I ask Mr. Turner a follow-up?
At this point, does anyone have any questions for Mr. Turner? Oh, right. Senator Kiffmeyer, could you state that again?
Well, Mr. Turner, I was just wondering if when it's along the way and it goes further, if some language could be added that says kind of like when you have two insurance companies, you kind of say, okay, this one has to be checked out first and they cover, and then the balance is paid for by the courts. And so language that would direct them to first seek reimbursement for these mental health needs from any insurance that the person would have.
Mr. Turner?
Mr. Chairman, Senator Kiffmeyer, we can certainly do that. In the meanwhile, though, I would like to suggest an oral amendment to the appropriation language.
Please describe it, Mr. Turner.
On line 2.4, strike district courts and insert Supreme Court. The Supreme Court would be the administrator of court reimbursements.
Any discussion on the suggested amendment?
Sure, I'll offer that amendment.
Senator Ingebrigtsen moves to amend the A1 amendment. First, lines 2.4 to strike the words district courts and replace with Supreme Court. Is there any further discussion on that amendment? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. Opposed? The amendment is adopted.
And then, Mr. Chairman?
Yes, Mr. Turner.
And then, Mr. Chairman, I will definitely look into Senator Kiffmeyer's suggestion and see if we can come up with an amendment for the Finance Committee.
All right. Ms. Turner, do you think that it would be ill-advised to do that now and instead offer that in the Finance Committee? That's where this bill would be going.
Mr. Chairman, I don't have the expertise on referencing medical assistance.
Yeah. Would that require this bill to go to Health and Human Service Committee?
I wouldn't think so, Mr. Chairman.
All right. It would be a finance issue. All right. Senator Anderson.
Thank you, Mr. Chair. This is for the author of the bill. I should say the amendment A1, where it says on line 1.14, the officer preparing the report may consult with any medical provider. And then further on, it says a court may consider. And I'm just concerned about the courts. I mean, I don't want to take away the flexibility of the courts. And yet, if there is a situation where there is believed of a person having had a mental problem or evidence that shows that they've had problem, we're basically saying that they don't have to if we put may in there. And so I'm just asking Senator Ingebrigtsen what his thoughts are, if may is the best thing they have in those areas, or we need to give the, go to shall or will or, whatever, Lord. Senator Ingebrigtsen?
Senator Ingebrigtsen?
No. Thank you, Mr. Chair. And maybe I'll have staff weigh in on that and better describe that for all of us, the difference between may and shall.
Mr. Backus, were you following that discussion on the questions of may and shall?
Mr. Chair and members, I was. In many respects, it's a judgment for the committee to make. On line 1.14, I don't know a great deal about how these reports would be made. I assume that the officer would likely consult. I guess if you wanted to say shall, it would be up to you. I don't know, how much discretion you want to give to the officer. On 1.24, the court, that's in some respects we don't often tell the court exactly what to do. If you again, I think the court would be considering it, but if you want to say shall, that would be your prerogative. I mean, it would basically just say that the court shall consider this. It wouldn't mean that the court would have to draw the ultimate conclusion, which is that the offender lacks substantial capacity. So, yeah, I don't know if that helps really at all. I think it's up to the committee. I'm not sure if it would add as that much to the bill, but if you can certainly add that if you wanted.
Senator Anderson, we've been getting into a lot of discussion about when the legislature wants the court to do something. And we probably haven't had that discussion enough, because the more we tell the judicial branch what to do, oftentimes they push back. And not because they disagree, it's just that they are trying to hold on to their territory and their authority under their own branch of government. And so I try not to tell the courts in definitive terms what to do. We can strongly urge, we can strongly suggest. I see that on line 1.6, we do use the word shall.
Right.
To inquire whether the defendant has a history. And that to me that's just me, but I think we're pushing the line on that a little bit. But it does give the court an indication of how strong a feeling we have on this general subject area.
Well, this tells me again that maybe we, as much as we need to look at people who are incarcerated, and yet because this is a health issue, this needs to go to a committee that deals with the health issues of individuals, whether they're incarcerated, whether they're normal, whatever the state of health they're in. This bill should also go into a health committee to have them look at it along with this. But I just thought, because it does say shall on 1.6, I thought to be consistent that we should go forward with that, using that word. But it's up to Senator Ingebrigtsen and the committee.
Senator Ingebrigtsen.
Well, Mr. Chair, I don't mind going to the health committee at all. It doesn't matter to me. I want to get it done properly. I don't want to put the courts in any kind of a wrangling, but at the same time, we are the ones that direct the courts to do things, as well as we do health commissioners. So again, we don't want to get lost here, fall through the cracks is the term. So whatever's suggested is the best way to get this thing done and get it done for sure. And maybe it won't get done for sure overnight, but nevertheless, I think we have to move on with this, because I go back to the testifier, Dad here, that comes here and explains that there's a prosthetic that gets to basically taken away from this person in prison, and what does that do? What does that do to her, and when she decides, if she can even get out, what are you gonna be releasing? I mean, somebody very angry, very, very angry, and very unsettled, and we just need to deal with this. So I'll take it to whatever committee, Mr. Chair, you decide. If you want me to go to HHS, I'd be more than happy to do that.
Well, Senator, Senator Anderson, are you done with your presentation or your question?
Well, Mr. Chair, I was just wondering about being consistent in the language and the bill. And then I just added the fact of going to the health committee. So if you want to keep it at may, I guess that's up to Senator Ingebrigtsen, or shall. From what Mr. Backus says, it doesn't really take away from the court system and making their decisions on this, or the officer, if we put shall in there. So I guess I'm okay. Mr. Senator Ingebrigtsen is the man in law enforcement, or former law enforcement. He's got better handle on it.
Senator Anderson, just talking about the process now, this bill is going to go to finance if passed in our committee today. I'm sure there will be other discussion following it. In the interest of time, I think we should send it directly to finance. Senator Kiffmeyer, do you have advice?
Well, Mr. Chair, I totally agree. This is how you pay for it, not whether it's a health need or anything like that. So I served on Health and Human Services for 12 years, well aware of the kind of bills that come before there. They would say, why is this coming before us? This is how you pay for it. not just because it mentions MNsure or Medicaid, does it make it a HHS kind of a stop? So I think I would agree it should go direct to finance.
All right. Any other comment about the bill? I just have one comment to make. Being a former correction officer, I've had to deal personally with people that really shouldn't be in a locked up cell block. People with a mental history or in need of mental therapy or treatment is exactly the wrong place to put someone. 40 to 50 years ago, Minnesota decided to get rid of its larger institutions. And there was good reason for that as well, but we never really backfilled the infrastructure on how to deal with it. And those individuals that did get in trouble with the law had no other place to fall but into the criminal justice system. Anytime you have someone in need of mental therapy or mental counseling or mental treatment of any kind in a prison, they either become victims of the remaining population, or they victimize others. So I think this bill actually moves us in the direction to direct the courts in a way that hopefully can get some good response, good positive response by the court system. Hearing no further discussion. Oh, Senator Pappas, you did have your hand up for a while, and I didn't want to neglect you. Did you want to interject at this point?
No, Mr. Chair, it was in regard to the fiscal note, which I saw, but that said 0, but Mr. Turner explained it.
All right. Thank you. Hearing no further discussion on this bill, all those in favor, if you members move your mic to on, all those in favor signify by saying aye.
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 Opposed? The motion carries.
Mr. Chairman, was that Senator Ingebrigtsen making that motion?
I should have made that. Yeah, I should have made that motion, Mr. Chair.
Senator Ingebrigtsen did make the motion, but then we got into a prolonged debate. So I was picking up from his motion.
Okay. All right. I'd even forgot about that.
All right.
Thank you.
Good catch, Senator Pappas. Good inquiry. We'll move on to Senator Rosen's bill.
Thank you, Mr. Chair.
Thank you.
Thank you.
Senator Rosen on Senate File 1279.
Well, thank you. Good morning, Mr. Chair and members. Senate File 1279 is the fentanyl and heroin same weight threshold. I always have to have some drug bill every year. This is my drug bill. I love it.
We're going to call you a druggie, Senator Rosen.
Whatever, huh? And as you all know, Mr. Chair and members, the drug overdoses are continuing to rise according to the Department of Health. And even with the work done to address drugs in this body, synthetic opioids, primarily fentanyl, account for the greatest number of overdoses.
Senator Rosen, before you go any further, I believe you have an A2 authors amendment.
I do.
I wanted to remind you of that so you could put the bill in its proper form as we hear your presentation.
Thank you, Mr. Chair. And I thought I'd just run through what the bill says and then see if somebody could offer the A2, which will actually really get it into the correct.
All right. Well, why don't you just continue, and then when you're done, we'll move it.
Thank you. So Senate File 1279 assigns the same weight and criminal penalty thresholds for fentanyl as for heroin. And the bill makes changes for, number one, the first-degree felony sale and possession, second-degree felony sale and possession, and then fifth-degree felony possession. The A2 amendment, Mr. Chair, makes changes to the third-degree possession, which was an honest omission. It wasn't caught in the bill. And it also changes the effective date from the date following enactment to August 1st, which is the most common starting date. So that's what that A2 amendment does, Mr. Chair.
All right.
Mr. Chair, I will move Senate File 1279, the A2 amendment. Is that what you need?
Senator Kiffmeyer moves the A2 amendment as an author's amendment. Members, open up your microphones, and those in favor signify by saying aye.
Aye.
Opposed? The amendment is adopted. Senator Rosen.
Thank you, Mr. Chair. And before testimony, there's currently fentanyl cases are charged as a gross misdemeanor in 5th degree cases because the weight threshold does not reach the 0.25 grams threshold necessary to be charged as a felony. And because of the extremely dangerous nature of fentanyl, a 5th degree fentanyl possession case would be charged as a felony when it reaches the 0.05 grams, which is the same threshold as heroin. So with this change from gross demeanor to felony, there would be a 5-year probationary period instead of 2. And this is a longer rehabilitation and a more stringent probation period, which is actually needed when it comes to fentanyl and the severity of the addiction. Mr. Chair, too, there is a fiscal note attached, but unfortunately, the fiscal note is written to not include the A2 amendment. And I would just, I don't know if Mr. Turner has any comments to that. It's a relatively simple and cheap fiscal note, but I'm not sure if the 3rd degree would change the fiscal note dramatically.
Well, we'll ask Mr. Turner. Mr. Turner?
Mr. Chairman, Senator Rosen and members, I put in a revised fiscal note request when we drafted the amendment. It should be ready. It will add to these numbers, but it shouldn't be any huge leap or anything. But since there is a fiscal impact in fiscal year 22-23, this will go the typical way of sentencing bills. It will go on to finance and either proceed by itself or be folded into the judiciary budget bill.
I'm sure our finance commissioner or finance chair will make room to accommodate this request.
I'm sure you will.
Senator Kiffmeyer.
Got it.
Thank you, Mr. Chair. I just have a question for Senator Rosen regarding fentanyl and the weight. Fentanyl is a hugely powerful drug in very, very small quantities. So I'm glad to see what you are doing, but I just wanted to have you address, because you're doing the same weight as heroin, and that must be accounting for then the powerfulness of fentanyl even in small amounts.
Mr. Chair.
Rosen.
Thank you, Mr. Chair. Yes, that's exactly right. And there's perhaps some other people that can give some weight to or substance to that answer as far as the testifiers that are before us.
Why don't we move, well, wait, Senator Kiffmeyer, are you done with your question?
Yes, I am, Mr. Chair.
All
Thank
right.
you.
I think we'll listen to our testifier and we'll gain a little more information. Mr. Mark Rubin, County Attorney Rubin, welcome to the committee.
Thank you very much, Senator. Thank
you. If you would introduce yourself and then proceed with your testimony.
Thank you. Good morning. My name is Mark Rubin. I'm the St. Louis County Attorney. It's my honor to be here testifying on behalf of the Minnesota County Attorneys Association and the people of St. Louis County. 43 years of being a prosecutor. This is only the 3rd time I've testified in a legislative setting like this. So I hope I can be of some help to you today. Senator Rosen, thank you for carrying this bill. This is a good start, okay? We have a serious public safety issue. And fentanyl, as all of you probably know, but just to remind you, is something that only is used generally in a patch or a lozenge. Nobody prescribes pure fentanyl in powder form or granular form. So if you have that in your possession, you have it for the purpose of using it and or using it to cut into another controlled substance. And therein lies the problem. Our death rates, overdose rates, are going up every single year in St. Louis County, across the state, and then in the Twin Cities area. I was just on the phone with a lab in New Hampshire. They have the same problem out there. It's a national issue. The problem is that heroin is often sold, but then the fentanyl is used and they cut it into it. We have some recent cases up in Hibbing, and what the dealers are doing, they're selling hot meth. Okay, hot meth means it's laced, or someone tried to cut fentanyl into it, or hot heroin, and even, and this should really alarm you, hot marijuana. Okay, the problem is fentanyl is so minute, it's so small of a concentration, chemists can't even cut it into something equally. And so we're trying to protect addicted people, okay? And the problem is people who are buying the drugs from a dealer because of their addiction don't know what they're getting. And they might get an extreme concentration of fentanyl in one dose, or somebody else gets hardly anything. So it can't be cut. The problem is it is such a profitable drug because it's the amount that is needed to produce some effect is so minimal, but it is so lethal. I'm sure you've seen other pictures and stuff too, but a 3 milligram, that's what might be left at the bottom of a pill bottle or just some, residue at the bottom is a lethal amount of fentanyl. Heroin, a lethal amount could be 30 milligrams. And right now, heroin is, if we can amend the statute to include fentanyl to be at least as serious as heroin, we're on our way. And let me make something really, really clear. Our medical examiner, Quinn Strobel, Midwest Medical Examiner's Office, she tells me that 60 to 70%, if not more, of her medical examiner cases, autopsies involve the presence of fentanyl. Okay, we're seeing the overdoses increase. People are our deaths are only being reduced because of the use of the Narcan. Okay, we're bringing people back to life who are overdosing on their way to death because of what it does to their breathing. The cops and the first responders are bringing them back to life. And again, we're trying to protect them. I've heard the argument, and I want to address this because I'm sure it's on your mind too. Some people say, well, you're just going to put more people in prison. Senators, I don't want more people in prison. If you look at my record and the record of most of the county attorneys across the state, that's not our objective. We want to hold people accountable. And in fact, Senator Rosen, with her making it clear that this would be a 5th-degree felony if you have any small amount of fentanyl. What happens to a person charged with a 5th-degree felony possession of a controlled substance? Well, at least here and in most places in Minnesota, they go into a drug court, they get a deferred prosecution. When it's done, they might not even have a conviction on their record. Our objective is protection and treatment of the people who are addicted. Okay, and why are they addicted? Why? Because of dealers. I know our laws reflect our morality. I get that, and I believe in that. Dealers need to understand that when they use this, when they lace any other drug with fentanyl, they will be held accountable. And I think that's the right thing to do. Is that going to change their way? Are they suddenly going to follow the law because you decree that this should be the law? I wish, but it'll be a start. And the other thing that we have to remember, fentanyl is not just a danger to the addicts. It's an extreme danger to our first responders, firefighters, other first responders. Why do you think they're wearing gloves, masks? They get that on their clothing. That stuff is so concentrated, it could be fatal for them. So, and I don't want to, overplay this or anything, but it is that dangerous. And you know what's sad? Because down the road is coming what's called car fentanyl. I'm told it's 100 times more deadly, more lethal than fentanyl. And again, these are manufactured synthetic opioids. Okay, it does what morphine does, what heroin does. And people know that there's an appetite, there's an addiction out there. We're doing our best to try to treat people, but we also need to hold dealers accountable. And I think Senator Rosen's idea here to get us started on the right track, to hold it, to put it up at least as serious as heroin. Lastly, let me just emphasize to you that right now, under the current statute, you need 5 times more than the threshold for heroin. You need 5 times more of fentanyl to be a first-degree charge. And it's ridiculous because fentanyl is 100 times more potent, more lethal than heroin. See, that's a flaw, and we can change this. You can change this, and it would just help us, because what do we do when we see a lot of these cases now? Lastly, I'll mention, we charge it maybe as a possession of heroin, and then we find fentanyl in it. It's the fentanyl actually that is causing the overdose. The fentanyl that is becoming the cause of death, notwithstanding the efforts to revive and use the Narcan. So I appreciate what you're trying to do, and I stand for any questions. Thank you.
There, Latz.
Thank you, Mr. Chairman and County Attorney Rubin. It's nice to see you again. Last time I saw you was in northern Minnesota at a very different event.
Boy, that's for sure.
I really appreciate your description of the impact of fentanyl and what you're seeing and observing and how it gets handled within the courts. It's very helpful for us to get some of the practical background on this, the day-to-day involvement that you and the officers that are investigating and responding to these calls are dealing with. And for me, that raises a couple of questions. One is, and maybe you can answer this, or maybe it's for Senate Counsel. If we put fentanyl here in the statute, is it going to be sufficient to include carfentanil when we start finding that in cases? I guess that's my first question.
County Attorney Rubin.
Thank you, Chair Liver. Good question. Some might interpret it. Maybe a suggestion, I guess Senator Rosen, I would throw this out there. Maybe fentanyl in any derivatives or, carfentanil. Somehow, if we can include the description for these drugs that are on the horizon, that would certainly eliminate that issue when we do charge cases. Thank you for bringing that up, Senator.
Senator Latz, before we go back to you, Cody Weiberg is also listening and would like to make a comment. If you'd like to ask further questions, you can. I just wanted to put that in your head that Cody is on board from the Department of Pharmacy.
Yeah, Mr. Chairman, Mr. Weiberg knows everything about all of the drugs that are listed in the different portions of the statute, and he'd be able to tell us if there is, if listing fentanyl will include all related terms, or whether we need to specify fentanyl directly in the or carfentanil directly.
We go quickly into the alphabet soup of the drug world, but why don't we ask Mr. Weiberg to make a comment at this point? Mr. Weiberg, would you identify yourself for the record and then offer advice?
Yes, Mr. Chair, members of the committee, I'm Cody Weiberg. I am the Executive Director of the Minnesota Board of Pharmacy. And I normally don't get involved in the criminal sections, but this question in particular is kind of right up my alley. A lot of law enforcement officers actually contact me about what they're seeing on the street. And my understanding is they're not seeing just fentanyl, they're seeing fentanyl analogs and fentanyl-related drugs. And those are listed in Schedule 1. And I think it would be a fairly simple matter to revise the bill to reference that the particular portion of Section 1 that those drugs are in. There are probably several dozen at this point fentanyl analogs and related substances that are listed in Schedule 1. And I think by adding some language like that, that would cover those drugs. And one provision in there is meant to deal with the common problem that happens with drugs of abuse, which is when you list something in the schedule, the street chemists find a way to tweak the molecule and turn it into something else. Well, one portion in Schedule 1 talks about if you take fentanyl and you change the chemical structure in certain ways, that new substance automatically becomes a Schedule 1 drug. And to the extent that law enforcement is correct, and they're also saying not just fentanyl, but these fentanyl analogs, based on the pharmacology, I think it would be important to include them because some of them are 100 times more potent than fentanyl, and fentanyl itself is 40 to 50 times more potent than heroin.
So, Mr. Chairman, I would ask Mr. Weiberg and Senate Counsel to consult on language that we could put in this bill that would make clear we're referring to analogs and derivatives and under Schedule 1's definition of fentanyl so that we can have that covered. And maybe while they're thinking about that, I can ask a second question, unless they have an answer to that first one at the top of the head.
Let's ask Mr. Backus, as far as timing concerned, if that's possible to do in the confines of this hearing, or do we give direction to counsel to move forward with Mr. Weiberg? Let's just see what the time factor is. Mr. Backus?
Mr. Chair, members, if I'm understanding it, the idea would be to put carfentanil in Schedule 1. Conceptually, that's a pretty easy thing to do. It's just, working remotely makes it more difficult. I would have to figure out a way to consult with Mr. Weiberg offline while you're still discussing this bill, and other questions relating to this bill I might have to answer during that time. So that makes it difficult. So I don't know how long that would take. It's certainly something that you could lay the bill over and we can come back to it maybe after the next bill. Or if I'm understanding the amendment correctly, and it's simply adding carfentanil to Schedule 1, I think if you were comfortable, you could do that as a conceptual amendment. And that's something I could produce after the hearing, because I think it's pretty clear conceptually what you're trying to do. We haven't done that in quite a long time in this committee, but in the past we've done that on occasion. So those are a few choices for you, Mr. Chair.
So, Mr. Chairman, I'm not sure if the solution is simply to add carfentanil to Schedule 1. If we mention fentanyl, the bill before us doesn't specify the reference to Schedule 1, and maybe that's implied. But so maybe just saying fentanyl in the current bill is enough to make reference to Schedule 1's definition of fentanyl, which means all analogs or derivatives as well. And if that's enough, then all we need to do is make sure that carfentanil and so on are covered in Schedule 1. If we need to do more, like add language to the current statute before us that brings in the definitions in Schedule 1, then we might need a little more attention to this. And I think the concept is pretty clear, but the manner to put it into effect might take a little more concentration by Senate Counsel and Mr. Weiberg. And I think as long as we've got this bill moving along, and if we can get ahead of the curve a little bit, we should try to do that.
Well, Mr. Chair.
Mr. Backus.
And that's, Mr. Chair, Senator Lutz makes a good point. If you look at the way the penalty provisions are worded, it refers basically to narcotic drugs, like say other than cocaine, heroin, fentanyl, or or containing it. So I don't know even that the scheduling, whether it's Schedule 1 or 2, generally matters that much with narcotic drugs like this. And that's something I'd want to review a little more and maybe talk to Mr. Weiberg. I mean, I guess one question is, I guess it wasn't clear to me, carfentanil currently, would that be considered at the very least a Schedule 2 within fentanyl or a Schedule 1? As long as it's a narcotic drug contained in Schedule 1 or 2, I believe the penalties are the same regardless.
Let's go back to Mr. Weiberg. Mr. Weiberg, you have your hand up.
Sorry, it was up. It was up from before, but I just actually sent an email to Mr. Backus about a potential amendment. Although I want to go back to carfentanil, that's in Schedule 2. So what I just sent him would need to be changed a little bit. But I think, after fentanyl, what you could potentially do is say something like, and fentanyl analogs and related substances listed in section 152.02 subdivision 2 and carfentanil. That would
that's good to inform the committee. Dr. Weiberg, I've been calling you Mr. Weiberg. I didn't mean to demean your title.
Not a problem.
I think we've got a gist of where we might want to go. And
to that point.
Yes, Senator Ingebrigtsen.
Doctor, is it your suggestion or determination that we should have fentanyl on a Schedule 1 or a derivative?
Dr. Weiberg.
Mr. Chair, Senator Ingebrigtsen, no, I don't actually think we could do that because fentanyl is FDA approved for legitimate medical uses. And if you put it into Schedule 1, that would not be in conflict with federal law, because in this area, the state can be more strict than federal law, but that would essentially mean that the FDA approved versions of fentanyl could never be prescribed, even for legitimate medical purposes.
Okay, and Mr. Chair,
Senator Ingebrigtsen.
even the derivatives would be the same, Mr. Weiberg.
Dr. Weiberg.
Mr. Chair, Senator Ingebrigtsen, no. The derivatives that are listed in Schedule 1 that are made up by the street chemists, those have no FDA-approved uses. They can't be prescribed. Now, carfentanil can be, but the way that what I just kind of propose as an amendment, that it wouldn't change the scheduling of carfentanil. It would just make the penalties the same as the penalties for heroin, so that could still be prescribed. But the fentanyl analogs that are in related substances that are in Schedule 1, they have no FDA-approved uses, and they're really dangerous. So.
Thank you, Mr. Chair, and I'll follow up with a question after the discussion. Thank you.
Thank you. Let's go back to Senator Latz.
So thank you, Mr. Chairman. So maybe council can get what they need from Dr. Weiberg, and we can take care of it. Now, I'm not sure that my other question is related to Senate Council, but it might bring in Dr. Weiberg, and that is, given that fentanyl is so much more powerful than heroin, and that carfentanil is so much more powerful than fentanyl, are the weight thresholds in the penalty section or in other parts of the bill here sufficient to reflect the seriousness of the substance? Or do we need to cut some of those weight thresholds by 1/2 or 1/40 or whatever the ratio? More powerful? Are the weight thresholds we have in statute adequate to accomplish what we're attempting to accomplish?
Dr. Weiberg, would you want to wrestle with that one?
Mr. Chair, Senator Latz, I think that's starting to get out of my area a little bit in terms of what the criminal penalties ought to be. I'm not really familiar with how those weight thresholds were initially established. I think that might be a little bit outside of my area.
And maybe I can help with this. I was asked to testify as well.
Could you identify yourself for the record, please?
Yes, Mr. Chairman. Thank you. My name is Nathan Benusa. I'm Assistant County Attorney in Sherburne County. I kind of brought the idea of the thresholds to Mr. Small's attention a couple years ago, but I can kind of talk about the amount of weights we're seeing and if whether the thresholds could be lower and whether that would make sense. As stated, it's an extremely lethal drug. It's a lot more potent at smaller amounts. We're rarely seeing anything above 0.05 for a user level. And then the people who are selling it, they're rarely possessing very large thresholds of the drug either, just from a practical standpoint. So, I mean, the thresholds could be lower. I think most importantly, at a minimum, it's important to at least get it at the same level as heroin at this point. Because we're seeing dealers, as Mr. Rubin pointed out, that to get to a first-degree fentanyl possession, you'd have to possess a very large amount that people just aren't possessing. I think the biggest issue going forward is that people who are dealing this substance are receiving appropriate sanctions. And I think as the statutes are drafted now, I think fentanyl dealers especially are probably receiving less stringent sanctions than they should. This obviously is a public health crisis. So I think going forward, it is very important to get the thresholds down to at least a heroin level. I think even lower would be more practical considering what's actually happening on the streets. But obviously, I think one step at a time is important. But if you would want to lower the thresholds, that would make sense from a practical standpoint as well.
Thank you, Mr. Benusa.
Mr. Chairman.
Yes, Senator Lance.
So I'm not sure how much we can bite off today on this, but this seems like the natural vehicle to address these questions. And so I think the natural follow-up to this is, how do we determine what would be the equivalent weight threshold between the current weight thresholds for heroin and the appropriate weight threshold for fentanyl, carfentanil, or related substances. And I'm not sure who has the expertise to help us determine that. And then whether we need to write that into these criminal statutes that are before us today. It looks like it might be the right place to do it.
Yeah, let me just ask the author, Senator Rosen. Senator Rosen, you obviously had some research done in order to arrive at the sentencing suggestion in this bill. Do you have reason to believe that we should be or have a more strict sanction due to the description of what we're dealing with now?
Thank you, Mr. Chair, for the question. And actually, no, I haven't really delved into that area. Perhaps Ms. Haas knows the answer, or Mr. Small, but it is a very valid question, and otherwise we'll be back at it again. I know this language, to make sure that we get the fentanyl language correct, is going to take a little bit of time. So it sounds like we may be laying this over and coming back to it. But if you'd like to finish the testimony, Mr. Chair, that might answer some of those questions.
Senator Rosen, I only have one testifier, County Attorney Rubin. There's no one else on my list. Do you have others that want to give testimony?
Yeah, I'm sorry, Mr. Chair. On my list, it was Mr. Small, Bob Small, and Nancy Haas. But
okay,
perhaps they aren't available.
We had Judge Small as a reference to if there were questions. So I see that he's on the screen. Welcome to the committee again, Judge Small. Would you first identify yourself for the record and perhaps give us some advice?
Thank you very much, Mr. Chair, members of the committee. My name is Robert Small, and I am the Executive Director of the Minnesota County Attorneys Association. The goal was to, because fentanyl was causing such a public safety issue, we wanted to at least equate it with heroin and the thresholds for heroin. Senator Latz has raised a very good and important question, but for the moment, we thought that at least equating it with the thresholds for heroin was the most important thing to start moving in this direction.
Mr. Chairman?
Senator Latz?
I think I have to rewrite my sign here. The one that says, Senator Limmer, you are muted.
You caught me.
I recycled. Wait, I might have it here. Hold on. Here we go. I have started to recycle it, but
You're starting to be hurtful, Senator. You're hurting my feelings.
if Mr. Chairman, Judge Small, do you see the value in following up while this bill is moving through the legislature on an evaluation of the appropriate threshold for fentanyl? Am I kind of on the right track, do you think? That maybe we need to adjust the thresholds? It sounds like what we're seeing on the street, according to Assistant County Attorney Benusa, is that the thresholds that are being carried are so low that they're going to fall below sentencing thresholds in our statutes. So maybe it's not enough just to list it in the statute. Maybe we need to have the thresholds adjusted to accomplish the stated purpose here.
Judge Small?
Senator Limmer, Senator Latz, you may be absolutely correct. As we were concerned at the County Attorneys Association was to try to address this significant problem. And, your suggestion that maybe the weight should be lower is excellent. As I said, we were just very concerned that it at least equal the weights of heroin. That was our focus.
I might want to just make a suggestion. Senator Latz, you and I both usually trigger the same question when we only have prosecutors giving us testimony. And for the purposes of balance, if they certainly knew about the original bill, if we were considering going deeper into this, I'd feel a little more comfortable to have a more well-rounded discussion. I'm suggesting that the original bill moves us in a significant step, and that there may be, well, it's always important to have any further discussion in this committee. I'm going to ask Senator Rosen to just weigh in here. It's her bill after all, and see what she might suggest at this time. I don't want to diminish the importance of this discussion, but I also want to introduce at least the concept of balance as we go any further. Defense Bar had been notified they were not privy to, or they were privy to this coming up, and they decided not to participate in this discussion as the bill is before us now. Senator Rosen?
Thank you, Mr. Chair. This is why I so look forward to coming to Judiciary, because you guys definitely think of everything that needs to be thought of in a bill. And I so appreciate Senator Latz's question and forward thinking on this too, and you too, Mr. Chair. I don't know if in order to keep this bill moving, I'm not sure if we have enough time to look at the amounts and adjust those. And that possibly could trigger a different fiscal note also, which I would be concerned about. And that would certainly require a lot more people to testify on. But I do think that the making sure that we cover all the bases on our fentanyl, whether it's the analogs or derivatives or some other kind of manufactured fentanyl out there that's coming down the pipeline, I would really appreciate that amended for this bill going forward. But I just don't want to stop this bill and miss deadline too.
Senator Latz.
So, Mr. Chairman, this has a fiscal note, so we're not bumping up against deadline today or next Friday, as I understand it. And I certainly don't want to cause this to not be able to pass. As you know, I think probably everyone here knows, I carried a bipartisan effort 5 years ago, I think it was, which made some very significant drug sentencing changes. And we did get into weight thresholds in that bill. And it is a more complex discussion. I appreciate the chairman reading my mind as well, that we should make sure we invite broader stakeholder participation for that discussion that would not necessarily have been concerned enough to come in to participate in the bill here today. So I agree with Senator Rosen that we want to make sure at least we get that First Amendment done before the bill moves on. Anticipating that we may have some time down the road, even after next Friday's deadline, to be able to schedule judiciary hearing on the threshold, on the weight threshold question. I don't think that it would stall the bill to the point of it being killed if we did that, but you manage the committee's time and schedule, and I'd have to defer to you, of course, as to whether that's possible.
Mr. Chair.
Senator Rosen.
This is great. I love this committee. That's teamwork.
I have never heard that from a state senator ever, say that they love this committee. You are a first, Senator Rosen.
Hang that on your wall, Mr. Chairman.
Well, Mr. Chair, I joined the committee. Doesn't that count for something?
You're a very valuable addition, Senator Kiffmeyer. Senator Rosen.
Thank you, Mr. Chair. I am definitely committed to it. And if Senator Latz would mind working with me on this issue and making sure that we can get the thresholds correct and everybody signs off, I would so appreciate that. Yes.
I personally would feel uncomfortable taking our council off focus of our day in order to make a fast amendment on an important expansion. And they will have better time use if we move this bill in its current form, with the idea that it raises serious interest in our committee to go a step further, but we don't want to rush this without an airing. So I think that's where I would direct the committee. Senator Latz, if you're done with questions, there's a few other senators that would like to ask questions.
Thank you for the indulgence, Mr. Chair.
Thank you. Senator Bigham.
Thank you. Thank you, Mr. Chair, and thank you, Senator Rosen, for bringing this bill forward. This is a really good bill. And, I know there was a reference a little bit before about maybe there were some things that needed to be added or whatever. I think there is one important discussion that probably needs to be had that continuously does not get had in this committee. And that's parity and equity, decriminalization of marijuana. And, we're talking about the parity in this bill of a horrendous drug. Fentanyl, carfentanil is laced in weed on the black market. And if we would legalize and regulate that, that's something this committee should take up, has refused to take up. There's been comments by majority leader, by other senators that want to have this discussion, and yet it doesn't happen. And I will say this: now, before I was born, And I think Senator Johnson and I have heard the 70s were fun. But our drugs, our scheduling, or I guess what I'm trying to say is, you know, the unprocessed, you have the flower, and then the processed marijuana that now happens in vape pens. And we need parity in that, Mr. Chair. We need parity in the fact that you can have raw leaf, you know, bud, and that has the same amount of THC as you know, other forms of that, and yet you get a petty misdemeanor if it's flour, you get a felony if it's wax, or it's completely unfair. And you know, there were good intentions when the medicinal marijuana law was passed, and you know, we sit here in 2021 and we still have 1976 scheduling issues that we haven't addressed. And so I'm glad we're having this conversation. This is a really good bill. It needs to pass. I do not have any amendments, Senator Rosen, so don't worry, I'm not going to do a surprise on you here. But I do think that this committee misses the ball by not having a conversation to provide equity in decriminalization, and there are huge disparities in our criminal justice system regarding this system. You know, I'm not a lawyer. I know there are some on the committee. I know that, you know, a petty misdemeanor is you know, a citation. I know, you know, obviously felony is a larger deal and has huge criminal consequences. And when it has the same potency, and yet we have such disparities in our criminal codes in this, it's a shame we won't have that conversation. So I hope that Senator Rosen would work with us to maybe even get that figured out in this amendment. But kudos, we need to pass this bill. It's needed. This horrendous carfentanil are on our streets. It's killing people. It's tragic for families. And we've addressed the dealer side of that, right? Like when somebody knowingly has laced marijuana and they're sending it. I mean, this body in this state has dealt with those types of issues, but yet we can't seem to muster to get equity and parity in our marijuana laws. So with that, I'll go back on mute, but I just wanted to put that before the committee and the discussion before the committee. And I hope that we do have a discussion on these necessary changes.
Senator Anderson, your questions are directed toward the bill before us, correct?
Correct.
Go ahead.
Thank you, Mr. Chair. Actually, it's just a response to thank Senator Rosen and her efforts and those who have signed on to her bill, to appreciate this issue, because January 30th of this past year, 2020, my step-grandson took a pill which, unbeknownst to him, was laced with fentanyl. And we're very fortunate to have him with us, because on the night that they took him to the hospital, he almost expired. And so we're very thankful. Any way we can make this bill stronger, I appreciate it, and look forward to the results. Thank you.
All right. Thank you. Senator Ingebrigtsen.
Yes, and thank you, Senator Rosen, for bringing this forward. And I think we should move forward with what we have and work on the amounts later. And I also would like to take this opportunity to thank the chair for standing strong against legalizing a very dangerous drug, whether it was accepted in the 60s, 70s, 80s, or 90s. Marijuana is still a very, very dangerous drug. And I appreciate the fact that we're holding strong on that, and I hope we continue to. I know Senator Bingham isn't going to agree with that, but we can talk about it offline. Thank you very much.
All right, let's get back to the bill. If there's no further discussion, the intention is that the bill will continue in its present form as amended, and with the help of Senator Latz and Rosen, at least, and of course, Dr. Weiberg, they'll work on the possibility of expanding the bill as far as the carfentanil issue. County Attorney Rubin, go ahead.
I know what you do needs to be based on facts and evidence. One fact I omitted, and I just happen to have the numbers here from our medical examiner for the year 2020. And I thank Senator Latz for going down this road. To me, it's more important to do the analogs and the derivatives than the weight, okay? Just last year, there were 37 cases where she found deaths. There was fentanyl, 4 cases. This gives you a good example of what the danger is on the horizon. 4 different analogs: carfentanil, valeryl fentanyl, methoxyfentanyl, and acetylphenol. That's 4 just in St. Louis County in 2020. So I think it'd be excellent if we could include the analogs and the related. So thank you very much.
Got a tidal wave coming at us, folks. It's actually been going at us for quite some time. Senator Ingebrigtsen, I'd like to move the bill.
I would too, Mr. Just one real quick question when we have the doctor here. Doctor, where is this fentanyl coming from?
Dr. Weiberg? I'm not sure if Dr. Weiberg is still with us.
Mr. Chair, members of the committee, I'm sorry, I was actually on a phone call with Mr. Backus. So if you could repeat what the question
The question is, where is fentanyl coming from? How is it getting into this country illicitly, illegally?
Most of fentanyl is coming into the country, imported by, I suppose, dealers and cartels. Some of it may be coming through the southern border from some of the drug cartels that are operating there. But my understanding is a lot of it is actually manufactured in China and then somehow makes its way to Mexico and then up into the United States. That's my understanding. And actually, that's kind of what I've heard from law enforcement folks that do contact me about these issues.
All right. Thank you.
Mm-hmm. Thank you.
Senator Ingebrigtsen, would you do the honor of moving the bill?
I would move Senate file, and you have it before you, as amended.
Yes, Senator Rosen, Senator Ingebrigtsen moves Senate file 1279 as amended, be recommended to pass and move to the Finance Committee.
That's correct.
Hearing no further discussion, members, turn your mics on. All those in favor of this bill, please signify by saying aye.
Aye.
Opposed? The motion prevails. Senator Rosen, you want to make a last comment?
Yes, thank you, Mr. Chair. I certainly appreciate your time with this. We are going to get this bill right with Senator Latz, anybody else who would love to work on this bill. I so appreciate that. And Senator Anderson, I'm so happy and grateful that you still have your grandson. That is tragic but a happy ending. So, Mr. Chair, thank you very much for this time. We'll get it straightened out in finance. Thank you.
All right. Thank you. Thank you, Senator Latz, for your contribution. We're going to be moving on to Senate File 116. And this is known as the Veterans Restorative Justice Act. It shouldn't be anything new to Senate members. However, despite the fact that we voted on it during the interim, this committee has never had a hearing on it. And I thought it would be a good time to give us a reference. It was referred to us from the Veterans and Military Affairs Committee. This is an informational hearing. There will be no votes taken. And it's our intention today to have a conversation and a fair public hearing on the bill. There are 4 testifiers listed on the agenda, and they were each given approximately 10 minutes to comment. The remainder of the time is have an opportunity for our members to ask questions. We will wrap up the discussion hopefully within an hour and then lay the bill over for further work at a later time. Our members have received delete everything A3 amendment. It's a technical rewrite, which is what the committee will be working from. And my hope is that the hearing, or that this committee will gain an understanding of the bill and how it fits into a real world application. And with that, we'll give the floor to Senator Chamberlain.
Thank you, Mr. Chair and members. The chair had mentioned this bill has been around for a couple of years. We voted on it a few times. And the goal is, as it has always been, that, and as this committee has worked on in the past, and we have voted on the floor in the past, if we can mitigate, step in, intervene, and take corrective action instead of putting people into a criminal justice system or into prison if they do not need to be there, then we have believed that would be a good path to follow. We've done it with sex trafficking and prostitution and some drug sentencing reform, among other things in the past. So the goal here with this bill for the last couple of years has simply been to address that issue. If we can intervene early and give options to veterans in this case who have been impacted by things, external sources beyond their control in certain circumstances, to keep them out of the system and out of prison, out of jail, then our intent was, our belief is that is a good idea for that person and for the community and for the state as a whole. So that has been the thrust and the goal of this legislation from the beginning. The delete all amendment fixes some technical problems, but it keeps the essence, as far as I understand, of the bill, it's permissive, allowing courts in the court to allow defendants to make a motion because they were a veteran and they suffered trauma or currently suffered trauma, that the court take that in consideration, follow a process to look at this particular situation in person. And if the person qualifies for a deferred sentence, for lack of a better phrase, then they could be put on a different path instead of being adjudicated through the normal process. And secondly, they would be counseled, they'd get treatment, and as long as they followed that treatment plan and stayed in it, they would could eventually avoid prison and maybe even a different probationary sentence in the end. If they did not succeed in that and they stepped outside of the treatment and they violated it, then they would be put back into the normal criminal system process. And it also eliminates, they are not every crime, not every person who commits a crime of certain types can get into this. As you can see in the delete all, there are a number of situations and criminal acts where this does not qualify. The defendant would not qualify for this deferred process and intervention. So it establishes a process, it's permissive, try to keep people out of prison and out of jail. They don't need to be there. It sets up a due process system to be followed by the courts. And if they fail, then they get back into the criminal justice system. If they succeed, they can have certain things removed and avoid prison altogether. And better for them, better for society. And not all criminal offenses qualify for this. So that's the quick, high-level, non-technical overview. And as you know, there are some testifiers, and we have one or two attorneys that are available to answer the questions, technical questions that all of you may have. Thank you very much, Mr. Chair.
Thank you, Senator Chamberlain. We'll move directly to Mr. Bill Ward, Public Defender Ward. Are you on board? There you are.
Mr. Chair, Senators, Senator Latz described earlier working together and getting a bill passed and drug sentencing reform. And I will tell you that this bill runs along the same gamut of people who worked on this to try to do something on behalf of our veterans. The VRGA was the product of 18 months of negotiations in a working group that included representatives of the state's primary group of prosecutors at the MCAA, veterans advocates, representatives of the state and federal departments of veteran affairs, and from the Board of Public Defense. We identified the need to address the effects military service has had on our returning veterans while recognizing the inability to establish dedicated veteran courts in all 87 counties in Minnesota. There was a robust discussion on the inequitable treatment of our veterans, whether a veterans court had been established or not, and how veterans themselves differed from one another, or the veterans courts, I should say. We believe the statutory solution was identified as the most equitable and expedient way to treat our returning veterans who are charged with criminal offenses. It was agreed by the working group that the most important thing that the VRGA could accomplish is to provide consistent legal incentives to those veterans suffering from the worst service-related conditions to ensure their compliance and substantial completion of treatment such that the district court identifies as necessary to rehabilitate and to prevent recidivism. After much lengthy debate, the working group was confident that to accomplish this goal, the bill must include more serious levels of offenses as those are committed by veterans with the greatest treatment needs. We understood that the charges must be at a severity level 7 or lower. And please understand that a 7 or lower is a person is presumed to be sentenced to probation, not execute a sentence to prison if they have a criminal history score of 2 or below. The difference with this bill and other actions involving level 7 or below offenses is obviously, as all of you know, the ability to receive a stay of adjudication. And it should be remembered that those charged with public safety and the County Attorney Association agreed to this because rehabilitating veterans who literally possess dangerous skill sets is a more effective way to protect public safety than even the most severe sentences available for these offenses. We need to treat folks who have the skill set, who were taught to kill overseas. When they come back here and are suffering from trauma, we need to rehabilitate and help versus punish severely with sentences. Understand that to be granted a dismissal, the now subdivision 3 of the VRGA requires the veteran must show substantial compliance with conditions of probation, that the veteran successfully participated in a court-ordered treatment, that the veteran does not pose a danger to self or others, and that the veteran is rehabilitated such that the legal incentive discussed with stay of adjudication is appropriate. The district court must be satisfied that all these conditions are met to grant the dismissal. We agreed as a work group that substantial compliance would take into account relapse and the other hurdles that one too often faces when entering treatment programs, and to avoid either the veteran completing the valuable parts of treatment without getting a formal certificate, or who gets a certificate of completion without really taking it seriously. So ultimately, the working group decided that the best way to ensure actual rehabilitation was a goal-oriented examination by the judge rather than a checklist that people just check the boxes that they did A, B, C, or D. Currently, individual county attorney offices and courts decide if they're willing to have a dedicated veterans court in their county, the rules by which veterans would be allowed to participate, and what legal benefit they will receive if the veteran participates. There are 29 counties with veterans courts, and so the majority have not established veteran courts, and the ones that exist have disparate practices that lead to more failures and successes, in my opinion, and from the folks that I work with. The disparate practice that currently exists concerns me, as it should all of you and all of our citizens. And that's why I chose originally to participate in the work group. I will tell you at the outset, I was not a willing participant at first. I did not like the way Veterans Court was being done in places, say, other than Hennepin County and a couple of other counties in Ramsey. I thought that the way it was handled was not good for our clients, frankly, The resources weren't available for the clients, and it was a patchwork effort at best. It should not matter, I believe, as a due process consideration where a crime was alleged to have committed. Whether you're in Isanti, International Falls, or Inver Grove Heights, all of our veterans should be treated fairly and equitably in the criminal court system. I know some might question the merits of the bill, and they say that they're in support of the needs of our veterans, but they aver that the bill goes too far. The reality is that our veterans are currently in the criminal court system now. They are in there today. As a society, we need to address the underlying reasons as to why one of our veterans found him or herself in the system. This bill provides for a consistent, fair, and effective approach statewide to address their underlying concerns, provide rehabilitative services, and support without having to establish 87 veterans courts throughout the state. Finally, I am not a veteran. Many of you on this call are, but certainly I know that our veterans sacrifice for us. The least we can do is provide the support they need when they find themselves in dire straits as a result of their services on behalf of our country. With that, Senator Limmer, I did not take 10 minutes. It was probably more like 3.5 minutes, but I will stand for questions.
Thank you, Mr. Ward. We'll move now to Ryan, is it Elsey?
Else, Senator.
Else, I'm sorry. Legislative Chair of the Minnesota Association of Criminal Defense Lawyers and was a member of the drafting group. Mr. Else, please identify yourself for the record and then proceed.
I'm Ryan Else, E-L-S-E, and I am also a veteran myself, as in addition to being a practicing criminal defense lawyer. There's a unique public safety and moral obligation that comes into play when we have a veteran whose service-related disorder brought him into criminal court. We've trained this generation of veterans to be the most lethal warriors the world has ever known. So it is critical that for public safety that we rehabilitate them when they're unable to keep themselves from committing crimes. And another effect is that the crimes that are being prosecuted by the same government that chose to send them to war. And so there's a moral imperative that we do not take a punitive approach to their behavior because we all have a shared guilt in that criminality. This bill gained the support of the County Attorneys Association, the Chief Public Defender, Violence Free Minnesota, the Social Services Association, Minnesota Department of Veterans Affairs, and all 9 congressionally chartered veteran service organizations because they recognize these obligations to our veterans and to public safety. I think whenever a bill comes before this committee with such broad support, it's worthy of your consideration. Mr. Ward addressed most of the technical points, but I will point out that I have been in pretty regular communication with Counsel Backus and have also drafted an amendment that would fully exclude predatory offender registration cases and would clean up the language for departures. So at some point, that should also be considered. I know we're tight on time, so I will leave the rest of my time for questions.
Mr. Else, would you release the amendment from Mr. Backus for us to consider, not exactly today, but for our perusal as we continue considering this bill?
Yes, I'm happy for that to be released. Maybe procedurally I messed up somewhere.
We're not voting on the bill today, so I was hoping we could take a look at it. Thank you. Is that ending your testifying?
Yes, I'll leave the rest for questioning.
Right. We'll now move on to Judge Carrie Meyer, Assistant Chief Judge in the 4th Judicial. Welcome, Judge. Thank you for giving us your time today. For the record, would you identify yourself again and then proceed with your testimony?
Thank you, Mr. Chair. My name's Carrie Meyer. I am a judge in Hennepin County District Court. I am the Assistant Chief Judge at this time. I was asked recently to look at this bill. I have the Delete Everything bill that I've reviewed, and I thank you for the opportunity to discuss sort of the changes this would cause for us in the District Court, as well as explain to you how it is that we get veterans courts in our state. I'm always happy to talk with you about treatment courts, so I'm happy to be here. I think the goals and sentiments in this bill are, of course, admirable. And I say that as a judge who presided over veterans courts for 3 years and as a mother of 2 active duty military members. Of course, I know that when they raise their hand to serve, some of them come back very different people. And there are things in this bill that address that. And that is, of course, the foundation for veterans courts as well. I'm glad there were many groups involved in putting this bill together. That was good to hear from Mr. Ward. But when I read the bill, I note that there are significant differences in this bill from the way that we do business in any other area. For example, there's direct contradiction to 609-095 and case law regarding stays of adjudication, because this bill would require the judge to do that even after a trial. There are different rules for where probation or veterans court would be supervised. The hearing at the end of probation is really a foreign concept. That's not what we've done, what we normally do. We only see people who are not doing well, or we have them in treatment courts where we have regular reviews and know that they're, and regular check-ins that they're doing well. And the BCA records process, the only other one I can think of is when a case is expunged that matches that recommendation. And there's no mention of the court record in this bill. Those are details, right? And I know that you can work through all of that, but it's just some things to think about as you consider this bill. I see the bill as having 4 main ideas, which are all great, right? Using veteran status and these applicable conditions to support departures, to allow veteran diversion programs to be put in locally, which would be maybe even pre-charging, but certainly pre-trial, to require stays of adjudication with multiple findings, and then to allow veteran treatment court programs, apparently without the approval of judicial counsel, however. As Mr. Ward stated, there are veteran treatment courts throughout the state, and we provided you a color map in your materials. You can see on your map, I don't know how you get your materials, but the yellow portions of the state do have active veteran treatment courts. There are 8 separate in the state. I only counted 25 counties, but I believe Mr. Ward. All of our treatment courts, including our veteran treatment courts, must be approved by judicial counsel after they go through a review and approval process from the Treatment Court Initiative Advisory Board. I'm a member of that board, so that's part of why I'm here today. It includes 8 district court judges, a tribal court judge, court administrators, county attorney, public defender, probation, human services, and community members all make up that advisory board. And we have the role of setting the standards for courts that call themselves treatment courts. That has been a national problem, that judges just say, I'm running a treatment court, but they don't know anything about the best practices or the evidence-based practices that are required to run an actual veterans court. There are 10 key components. Many of them are included in this bill. I appreciate that. But we review those. We work with the people who are putting their veterans courts together in our state, make sure that they create, implement, and continue to run their veterans courts appropriately following those 10 key components. Of course, I'm disturbed to hear what Mr. Ward's saying. Again, I have no reason to doubt him, but those type of issues should come to the TCI for review if our veterans courts are not following the 10 key components anymore. The other thing that board does is distribute money that's earmarked from the legislature for treatment courts. Most of our veteran courts continue to get federal money more than needing the money that you earmark for treatment courts. Veterans courts are special, of course. They assist those members of the armed forces who were changed by the way that, by the realities of their service, and then who became justice involved. And so we want our veterans to have access to veterans courts in the state, but it's not just a judge, attorneys, and probation officer. It's all of our other representatives from Veterans Administration, Veterans Benefit Office, the county veterans service offices, and other community groups that work with veterans. One thing that I'm sure you're aware of, members of the committee, that even counties that do not have veterans courts still have an obligation. Every judge has an obligation under state statute to know the veteran status of the defendant before them. 609.115 regarding pre-sentence investigations requires the judge to ask probation to tell the veteran status, and also when there's a documented mental illness to get input from veteran organizations and treatment providers to have the best treatment to address any issues that may have come from their service. So I'm here more for information if you have any additional questions, but I just wanted to give my initial thoughts and give you background of how treatment courts are approved in the state.
Thank you, Judge. Appreciate it. We'll now move on to Mr. Tom Fournette, Assistant Washington County Attorney. Assistant County Attorney Fournette.
Thank you, Mr. Chairman.
If you would identify yourself for the record and then proceed.
Thank you. Thomas Fournette. I'm a Washington County Assistant Attorney. A little bit of background of me. Prior to being a county attorney, I was in the Marine Corps. I was an enlisted Marine in a rifle company. I served two tours in Iraq, first one being during the surge in 2006, and then a subsequent tour after that. Following my military time, I then came home and went to law school, became an attorney, and I've been a prosecutor in the adult division for probably 3 years now. So I'm glad to be here. I want to thank all the other testifiers that came before me. I thought they brought up some great points. I'm really happy that Judge Meyer is here. She brings up some great points, the one being the 609-115, because I want to talk about that. But she did a good job. I don't want to take up too much of my time talking about my past experience, other than to say that it's a difficult time for combat veterans to come back to the United States and figure out where they are in the world. It's a foggy area where a lot of them are just lost. And if you have veterans that start using alcohol or substance abuse, that just leads to criminal behavior. And they find themselves in situations where they are having to face criminal charges. A lot of times there's diversion courts that might be able to address that. Other times there's not. So I'm glad that we're talking about this. I think that everybody here wants to get some veterans restorative justice bill passed, and we're moving towards there. I think this is a good framework. Obviously, maybe some things need to be tweaked. Maybe some amendments like Mr. Els had brought up really kind of also address a little bit of my questions that I would have for that. Definitely. Judge Meyer's comments and her input from the judicial side is always good because they see things from a different perspective. But when I look at this as a prosecutor, it's a difficult thing to have a veteran in front of you who comes in and is probably hit rock bottom. I speak because I work in our veterans court. 90% of the time, I would say that this person has some type of alcohol or chemical dependency problem, and they either get a DWI or unfortunately, they get involved in a domestic abuse situation. In those type of cases, and I want to talk about the domestic abuse cases a little bit more at length, we've had great success with helping veterans get treatment, work a program, and really own up to what they have to do to get better. Also, the spouses or the people they're involved in a relationship with, at least in my experience, have always been in support of trying to go down the route of giving this person treatment and having them avoid some type of criminal history or a criminal conviction. That was surprising to me, but overwhelmingly, spouses or people in their lives all support, I just want this person to get back to as normal as they were before they left. And we've had good success with it. I think that these type of programs and any type of diversion court, I was listening to testimony earlier on the other bills. I think when we have an individual, what we really want to do is find out what's causing them to put themselves in situations where they're committing crimes. And if we can break, for instance, a cycle of violence is happening in a domestic abuse situation, then that's a success because we've treated that person, we've diagnosed their problem. And hopefully by doing that, they don't continue to have these type of issues. But I know you might have a lot of questions and the day is getting kind of late. So I'm going to end my testimony on that point and I'll take any questions that you might have.
Thank you, Mr. Fournette. As we get into the discussion, the A3 amendment is kind of a rework of what I think was kind of model legislation that's been used in other parts of the country. If I'm wrong in that, please correct me, Senator Chamberlain, or County Attorney, is it Mr. Else? Do you want to?
Yes, Senator. We started in the working group when we decided that we were going to look at the legislation. We started with the California bill, but there's been very significant modification to it based on the input of the working group.
Yeah, our researchers looked it over too, at least the bill that we knew of last year, and they put it in the form of A3 to make it as to fit into how Minnesota does things. And
yeah, so Mr. Backus did a wonderful job of that.
Great. Yeah, Mr. Backus is highly skilled.
Yeah.
And so I'll open it up for discussion. If anyone has questions, comments about the existing bill, Senator Kiffmeyer, want to lead it off?
Thank you, Mr. Chair. First of all, just to lead off, I think we all agree in many ways on the goal. We agree on the goal. My husband is a Vietnam veteran who took care of direct battlefield casualties in Vietnam in the emergency room where he worked there, and also with injured civilians. So great deal of sympathy for that. The question here is how to do it. And one of the things I'm wondering about is we already have currently veterans courts in Minnesota. This seems to be a whole different style. It seems like wouldn't it just make more sense to expand what we already have? Why is it necessary to look at doing something like this, which is very different?
Who would like to answer that question? Mr. Ellis?
Yes, thank you, Senator. The reason why is that there are limited resources, especially in a lot of the rural counties, that prevent a full veterans treatment court from being stood up. And for whatever other reasons, they're not being stood up. And this bill aimed to make it so that any court, regardless of whether they had a full treatment court or not, could follow a basic treatment court model. It's also why we came up with what is, like Judge Meyer pointed out, a very novel hearing in this end of supervision hearing. This is not something that exists currently in criminal practice, but the only way we could work with the County Attorneys Association and get their trust that the veteran was coming out the other side of the process actually rehabilitated rather than having checked the boxes of, attending treatment like is currently done on probation, was to have this end of supervision hearing that has very direct standards that the judge must evaluate the veteran's performance by. And so that was why we saw this as a a more effective way of dealing with the problem of disparate treatment in various counties and the lack of access in other counties, was to deal with it by statute rather than individual courts.
Mr. Ellis, have this version of the bill or your bill that you had that we rewrote on your behalf, had you ever presented that to the Judicial Council for their review?
It was presented to the Treatment Court Initiative by Mr. Hunter. It would have been probably 2 years ago now. This bill's been around for quite a while, but it was while we were in the drafting process with the working group. And I don't have the exact date available, but I do know he presented the bill to them.
And what was the outcome of after you made that presentation?
I've never heard of any objection from the TCI. I know that with a lot of the judges that were involved in that working group, they pulled back once we started working on legislation because they were afraid of some conflicts of interest. So we haven't heard a whole lot from the judicial branch since.
Mr. Chair, I just wanted to follow up one other thing that relates to it. Thank you, Mr. Chair. So question I have is, what would this system do when you have already these veterans courts? So how would they intersect, not intersect? Would they go away? Because now we're going to have two paths, or proposed one path. We have this other path. How does that all work together, or does it, or what would that do?
Yes, Senator. What the intent is that the only thing this would change for existing veterans courts is the stay of adjudication model in the courts that don't currently offer it. Otherwise, this shouldn't modify any part of the actual process of the veterans treatment courts. That's why subdivision 5 is in the bill, is to make clear that this can be supervised under veterans treatment courts. And so the process should remain pretty much the same, that it will only change that disposition issue, that the legal incentive the veteran has to finish the course of treatment.
Senator Kiffmeyer, further? You're on mute, Senator.
Mr. Chair, I think the question I have though is, so we'd be having two different systems for treating our veterans is what I hear you saying. So the veterans courts would still stay in place with the stay of adjudication language, and then we'd have this other one going on. I think somehow we need to address that, because veterans are going to get confused. Other people may get confused, and maybe I'm confused and not understanding it enough. No question about that possibility. But I think that would be a concern that I would have. But I know this bill is being laid over and being worked on. So I'm trying to bring up some issues that might help things be worked out. So when we review it again, we can maybe move forward. Thank you.
Before we go any further, Judge Meyer, do you remember when this proposal was presented before the Judicial Council? Can you recall what their reaction was? I heard that they weren't opposed, but I'm not so sure that they were embracing it either.
Thank you, Mr. Chair. So I was not on TCI 2 years ago, but I just heard back from our treatment court coordinator for the state. She indicated that Mr. Hunter did not present this bill to TCI. He gave a presentation on the Veterans Defense Project and the working group, but no actual legislation has ever been presented to the group. And that was my understanding when I was asked to come in, is that the courts just haven't been asked to weigh in on this yet.
All right, thank you. Senator Kiffmeyer, did you have further questions?
I may have, Mr. Chair, but not right now.
All right, Senator Anderson. You're on mute. There you go.
Thank you. Thank you, Mr. Chair. That's what the question you asked Senator Chairman Limmer to Judge Meyer is a concern of mine, is that she mentioned in several of her points that there is going to be some differing ways of doing this proposal versus what they're doing now in the veterans courts. And I just wanted to know if you could elaborate, Judge Meyer, in ways of the different, the stay of adjudication and the BCA process and things like that. If you could give us some further details of your concerns in those realms that you mentioned.
Judge Meyer.
Mr. Chair, Senator Anderson. So I don't know how much in the weeds you want to get. When this bill was first proposed, Hennepin County did not have a stay of adjudication treatment court, veterans treatment court. But after this was proposed, County Attorney Mike Freeman decided this was the way to go. And so the Hennepin County Veterans Treatment Court has changed to a stay of adjudication court now. And I think that's Mr. Ward's point from earlier. Not all the courts have. And so the veterans courts are different from each other now in how people come into the court, whether they have to already be adjudicated, whether they end up with a permanent felony record, whether they get their case dismissed at the end. Those things are different from veterans court to veterans court because that's not a requirement of the 10 key components that everybody comes in with the stay of adjudication. So in a way, this bill would actually unify the way that veterans would be treated if they can meet this threshold of showing that they have this, I want to use the right word, the applicable condition, not just the eligible offenses. And I don't know, I mean, I think that's really hard to show, right? That someone has a substance use disorder because directly as a result of their service. I wouldn't want that to be a requirement to be able to get into Veterans Court. It's certainly not a requirement to get into Hennepin County's Veterans Court. If we just did these group of folks, right, with the applicable conditions, we actually would end up excluding veterans. And I know that's not Mr. Elsa's point, right? That's not his goal at all. And so that's one, I don't know how many things I just said, but those are differences, right? Stay of adjudication is not normally in the court's authority. That's 609-095, a lot of case law. And so this is really different that way, to say that after trial or after a guilty plea, as long as the defendant asked for it and the court found that this case was related to the applicable condition from their service, then the court would be able to stay adjudication even over the prosecutor's objection. But there's prosecutors involved in this, so I don't know. It's just, there's other things that would have to be modified, other statutes that would have to be modified in order for this to be able to take place, was really my big point in my comments earlier.
So Judge, would you say that there's no real comparable framework in existing law than what this bill presents? At least in a narrow perspective?
Yeah, Mr. Chairman, when I looked up the phrases that are used in this bill, the only one I found was failure to pay child support can get a stay of adjudication if it's prosecuted as a crime that you failed to provide child support, and then the judge can stay adjudication. And that's written right into the stay of adjudication bill as well, right? It's in both spots. And so that's the only place I could find that was like it at all. And then, there's things that they monitor, but this is, it feels really different to me. And I'm not saying it's impossible at all. I'm just saying it's different, right? For the defendant to have the burden at the end of probation period to say, look, I did what I was supposed to do, I'm changed, instead of probation having to say there's a violation. So it's different, right?
Mm-hmm. Mr. Backus, our counsel, wants to weigh in. Mr. Backus.
Mr. Chair, members, I might be able to piggyback on that a little bit. If you're interested in learning, like, what we have that's similar in law, I think that the judge started mentioning that. We do have a few stay of adjudication / discharge and dismissals in law. One of them is for the failure to pay child support, as she mentioned. We also have it in the drug law, 152.118, which is for lower level drug possession cases. However, it's limited to specific crimes. It's limited essentially to first-time offenders, and it gives the judge, for the most part, discretion to do that. It wouldn't require it, as this bill would do if the requisite findings were made. And then, as the judge mentioned, the bill would need a technical amendment at some point to amend 609.095 to indicate that this would be another example of a discharge and dismissal / stay of adjudication. So that's something we could easily do. But under current law, the parties can agree to a stay of adjudication as well, but that wouldn't involve the discharge and dismissal.
Thank you, Ken. One of the questions I had, and that was on the I guess it's on page 2, where it starts out 2.5. The big word that I see that jumps off the page is shall rather than may. And oftentimes, and anybody who works in this committee realizes that over the years, the legislature has been trying to direct the judicial branch from time to time, and they don't always receive that direction well. And so whenever I see the word shall, it raises a red flag with me as far as the direction. I try to honor a separation of power as much as I can in the legislature. I do know that there are times when we do that, but I try to make sure that it's over minor issues and not a rewrite of a judicial process. So could someone direct me or answer the question of why do we have the word shall in the legislation? Mr. Ward.
Thank you, Mr. Chair. The reason being is it's the incentive for the veteran to seek that treatment and go through those hurdles. We recognize very thoroughly that the Senate and House do not like using the word shall. But let's be honest, we use the word shall a lot when it comes to mandatory minimum sentences and punishment. We're asking for the word shall to be used for a stay of adjudication to give a break to a veteran who has jumped through tremendous hoops. So yes, it's at the beginning of the proposed bill, but in order for that to happen, as Judge Meyer pointed out, it's unique. We need to show, the veteran needs to show that he or she has completed everything they needed to do to fulfill what they had to do to be rehabilitated and follow their programming. It's after that occurs is when the court would then stay the adjudication and not enter a judgment. So it's a stay, yes, but ultimately it's proof of progress and completion by the accused for that to occur.
But Mr. Ward, this language doesn't seem to take into account the position or the role or the wishes of the sentencing judge or prosecutor. Mr. Ells?
Yes, Senator, the idea behind the shall language on the front end of the bill was to cast as wide a net as possible. So to bring the veterans into this treatment program. Then it's at that end of supervision hearing where the judge has a lot more discretion to then take into account the harm to the community, the veteran's failure to complete treatment, or any other circumstances that would warrant not giving the full dismissal. But the idea was that by using the shall language on that front end of deferring the prosecution, that we would bring the most veteran defendants into this program. And then they have to earn it from there.
Mr. Ells, is the victim ever involved in it?
Yes, you'll see it. The at the end of supervision hearing, it says that the victim shall have notice of the hearing and be, and the judge shall consider the level of harm to the community or victim from the offense. And I know from conversations I'm having on the House side that they're requesting a more direct language referring to a victim impact statement. I wouldn't be opposed to anything like that. If I think it's inferred by what's here, but if it's not direct enough, that would be just fine.
So going back to the shall, am I to assume that you don't think a judge can ask these questions or consider this on their own?
I think Senator, the concern we have is that right now, this could be done by any prosecutor in the state, and it's not. In a lot of courts, this is not the disposition that veterans get. They do not get the benefit of a stay of adjudication. And what we were hoping to do by having very direct shall language is to make sure that the courts are as consistent across county lines as they can be, and without completely eliminating judicial discretion. And that's how we arrived at this process. As Mr. Ward pointed out, this was 18 months of a lot of back and forth. And I know that this committee hears from the County Attorneys Association enough to know that they would not, without a lot of diligence, and agree to this sort of process. And so, this was thought through very carefully as far as where judicial discretion is appropriate and where we should be more directive.
Senator Latz.
Thank you, Mr. Chairman. A couple of questions, if I may. First of all, could you explain why you are approaching this bill as an informational hearing rather than a regular hearing at this point in session to consider passing the bill?
Senator Latz, in our preliminary review of the bill, we were getting a lot of questions on how this bill would work and how it would fit into Minnesota judicial practice. I believe that this bill may need a little bit more work and participation, hopefully, by the Judicial Council as well as what's before us, hoping with the idea that this could be worked out in the interim and that we have a bill that's well polished and something that would serve the best interest of our veterans.
All right. Yeah, it's not normal to have an informational hearing at this point in the session, but certainly the information we're getting is interesting and helpful. I guess we'd have to see how quickly we can get concrete input.
Yeah.
This and be able to turn it around into actionable legislation that would make people comfortable with it. In partial response, at least to your question about the mandatory language, I guess on that particular point, I have to agree with Mr. Else. This legislature has a habit of dictating to the judiciary with regard to sentencing. Earlier this week, I believe it was, we passed, I believe, the strongest, lengthiest mandatory sentences anywhere found in statute having to do with assault on police officers, where a person could face a 25-year mandatory minimum sentence, no judicial discretion whatsoever to consider any factors. And that would apply to even a juvenile that committed the offense. So a 16-year-old who would commit that offense, or even a 14-year-old that committed that offense, if found guilty, the judge would have no choice but to sentence that person to 25 years in prison without the possibility of any parole anywhere along the way. As the members of this committee know, I raised questions about that during the hearing. But I'm not as concerned about utilizing the term shall where we think it's appropriate. I think the question for us is whether this is an appropriate place to do it. And we do, in the stay of adjudication realm, already mandate stays of adjudication for under Chapter 152.18 for first time certain drug offenses. The other point I'd like to make at this time is that I've got information, I believe that the Chief Justice was presented with at least an outline of the content of this bill, if not a detailed description, and that at this point has indicated a neutral stance on it. I don't know if for sure if that's a public statement that she has taken, and if it was on behalf of the judiciary, or whether it involved any additional consideration within the judicial branch, but it might be worth fleshing that out. If in fact it's a neutral position, that's an interesting point in and of itself. But we might want to get that information as well. So at this point, that's all I have, Mr. Chairman.
All right. Senator Johnson.
Well, thank you, Mr. Chairman. I just reading the bill here and juggling kids. I'm sorry, I may have missed something at the same time. But I just wanted to go back to the underlying premise of the bill here. This seems to me like we're taking into account or trying to treat military veterans who have seen some sort of combat-related PTSD or trauma that may lead to substance abuse and those sorts of issues that come along with it. Is that defined within the bill? And maybe I should take a step back. Are those the people that we're really trying to go after with this bill?
I'm never going to get used to this. Mr. Ellis.
I've stepped on that quite a few times myself, Senator. We're trying to capture any veteran whose service-related condition, whether that's from direct combat or military sexual trauma or any other military-related condition, is committing a crime because of that condition. Sometimes those are violent crimes, sometimes they're crimes of addiction, but those are the veterans we're targeting.
Senator Johnson.
Mr. Chair, and I appreciate that, and I am very, very thankful for the service that our military men and women give. But then I also think about our law enforcement and the trauma that they see, or our EMTs and the trauma they see in serving the public in a different but similar capacity. And I wonder, is there a system like this for those other professions in which they're serving the public as well?
Mr. Ellis?
There's not now, but I would be fully in support of such a system, but for the same reasons. That especially in the areas you cited, the government is partially involved in the trauma that led to the criminality. And so it does involve kind of that same underlying justification.
Senator Johnson?
I'm good, Mr. Chair. Thank you.
Mr. Ellis, there's a number of veterans that go overseas, combat theater, but there's many of those individuals that never see combat. They don't have the same degree of traumatic experience than those on the front line. Despite that, it seems like the bill recognizes any and all veteran. I don't even know if it says that they would see combat. And so why would we have this bill written so broad when it comes to a veteran?
Yes, thank you, Senator. The point was to stay as close to the current Veterans Treatment Court practice as Judge Meyer laid out, of letting in almost all veterans, while still overcoming what has been seen as an equal protection argument and a concern of the County Attorneys Association that there be a nexus between the crime and some sort of condition that developed as a result of their military service. This bill wouldn't include all veterans because the veteran does have the obligation of showing a connection between the offense and the service-related condition. And that is the product of trying to deal with that nexus problem that was a concern for prosecutors. Some of this is just the result of negotiating and a recognition that the stay of adjudication is kind of extraordinary relief, especially when you're talking about a more serious felony. And so the initial showing was really important.
And Chair Limmer, if I may, Bill Ward.
Yes, Mr. Ward.
And what Mr. Else is referring to is in subdivision 2B. It talks about, I think it's on line 2.12. I'm sorry, 2.13. The defendant, through existing records or licensed professional evaluation, shall establish the diagnosis of the condition, that it was caused by military service, and that the offense was committed as a result of the condition.
So it doesn't specifically say the word trauma or PTSD?
Mr. Chair.
Senator, that would be under the, sorry, Senator, for just jumping in like that.
All right.
The condition would come from the definition section of applicable conditions, including sexual trauma, traumatic brain injury, post-traumatic stress disorder, substance abuse, or a mental health condition.
All right. Senator Anderson. And Senator Johnson, your hand is still up. Do you have another question?
No, Mr. Chair. Is that better?
All right. Senator Anderson.
Thank you, Mr. Chair. Appreciate the opportunity. It was mentioned earlier that veterans are going to have to show some kind of, in 2.2B there, that subdivision B of subdivision 2, that they have to show some kind of reason for or a diagnosis of their condition. And I'm wondering if either Mr. Fournette or Mr. Else or Mr. Ward, whoever, do veterans get a medical or a mental health test or physical before they leave the military? So there is a diagnosis that's been made that comes from the military saying that they have a problem?
Mr. Else.
Yes, there is a process where on exit from usually after a deployment, there is an evaluation done. That is, from my experience, both on my own deployment and the veterans I've represented, somewhat of a canned process. Everyone in the process knows that if you raise your hand and you say, yes, I'm suffering from nightmares or recurring thoughts, that you're not going to go home with everybody else on the same time frame. So most of that evaluation comes from the Department of Veterans Affairs after the veterans come out of the military.
Judge Small, did you want to weigh in on this question?
Thank you very much. I did not. If there was a question, I was prepared to answer it. Mr. Else answered it very well, and having run through that same experience, I know exactly what he's talking about.
All right.
I'm just going to be here to help.
Okay, thank you. Senator Anderson.
Thank you, Mr. Chair. Early on, I think Mr. Ward mentioned that in establishing these courts statewide, that they were looking for resources, or there'd be necessary resources required to implement this system. And I'm just would like to know if he's got some details on what those resources are and how much they cost us.
Was that directed toward Mr. Ward?
Mr. Ward or whoever.
All right.
Mr. Chair, members, I know that Judge Meyer will have those costs for sure. There is a cost involved. There is a huge need for cooperation. And if I'm wrong on the 29, it's only 25. We're talking about a substantial number of counties who would have to establish a veterans court program. The funding would come from different funding sources. To acquire that funding would take some time. To establish the court would take some time. The concern and the immediacy on this is the circumstances that this country is faced with how many people are returning to our country who are suffering from trauma and who are committing crimes. And that was the reason that we chose to work together as we did in a very unique way to try to come up with a solution to address these very serious issues of people who've been deployed 3, 4, 5, 6, a dozen times. So I have a very long-winded answer. I don't know the numbers. I know it takes time. I know it takes currency. I know it wouldn't make sense in places like potentially Kuching County or other smaller counties. And that's the reason perhaps why the veterans courts have not been set up. But what I do know is we have a statewide public defender system, and our clients are being treated different depending on the county line in which they are accused. And that concerns me very, very much. What Judge Meyer and her staff and the stakeholders do in Hennepin County is to be lauded. Now that you are now doing stays of adjudication that you weren't doing before, which is why I pulled us out of there. But we don't have that same opportunity for my same clients in, say, Sherburne or Elk River or Stearns County. So that's why this bill is so important. I want to reiterate this. This gets lost. The idea here is that, and I appreciate Judge Meyer's concerns, but the idea here is to have a format, a bill in place where veteran status, although it has to be taken into consideration now, this is a way to use federal resources, Department of Veteran Affairs resources, to follow the right programming in the counties that will actually assist people versus using the same old rehabilitative services. It's focused on the veterans and the situations they're faced with, not other types of situations. To be able to establish 87 of those counties, I will be retired by then. And I'd like to do something on behalf of our folks before that happens.
Mr. Ward, treating a veteran who's had some type of diagnosis of a condition and giving them a special court treatment versus someone else who was not a veteran, doesn't that raise a question of equal treatment under the law?
Mr. Chair and members, I think that's directed at me because you know what my response is going to be. And that was a huge concern I've had as a part of this work group, is to why would we treat some people different than others? As I stated at the outset, I'm not a veteran, but I know what these wars for the past 20 years have done to our citizens. And it is a government-sanctioned training to literally murder people in other countries. And then they come back and need to be reintegrated into society. So these aren't folks who are doing this on their own. This is folks who have enlisted, who have been trained a certain way, have been put into a theater, and then are brought back home and are expected to conform the same way before they left. And it's because of that, that's the reason why I thought it's appropriate. It is appropriate to look at it differently because of the government-sanctioned training and ultimately, as it happened from Vietnam, dropping them off here without the support. And so without support, without the services that are out there but are not being used, we are going to have a years of frustration of folks who cannot comport based upon the training we gave them to fight for us overseas.
Well, I think as we look at this, again, I'd like to emphasize what Senator Kiffmeyer gave us in the very beginning, and that is we all agree with the goal. And now how do we make the system work, hopefully in a uniform manner? And is it in line with constitutional principles, as well as what kind of resources will it take? Senator Latz.
Thank you, Mr. Chairman. Could Mr. Ward elaborate a bit on what he said about pulling the public defenders out of Hennepin County relating to the stay of adjudication?
Sure. Mr. Chair, Senate members, The reason I did it is because they were post-adjudication courts, and ultimately the case is resolved. And with our limited resources, you know, how are we supposed to be going back there? That'd be like us representing people after they've been placed on probation. We didn't have the ability or the time or the resources in order to do that. So it wasn't out of anger or frustration. It was really a systematic resource issue of not having the bodies or the expertise to do so. And I've been consistent across the board on that too. Pre-adjudication is different. The cases are still alive, right? And ultimately, because the clients are still in the system, you know, it's important for us to be there on their behalf. Post-adjudication, as much as we like to be there, we don't have the bodies to do that. And Senator or Chair Limmer, if I can just respond, you know, to you and Senator Kiffmeyer, you know, currently we don't have equity in the system. You know, currently, if there isn't a veterans court, if you're a veteran, you're treated completely different in other counties. You know, currently, how the system exists is unfair. You know, it's a due process violation. Currently, you can be in Beltrami County for the exact same charge up there and be convicted of the crime in a veterans court, and be in Hennepin County for the exact same crime, same background, and not have a conviction. So the current system is unduly unfair the way it exists. What this bill does is attempt, and at least we thought it was a decent attempt, other than what I'm hearing here, is to have some conformity for the 87 counties and a framework with which, if you didn't have the resources of sort of veterans court, you at least have the ability to say, these are the reasons for why. Can you show that the event occurred due to your trauma, due to your having been enlisted, and ultimately the resources that need to be used, and ultimately for the person to achieve those gains in order for them to not have a conviction? That to me is conformity, and that this bill is 100 times better than what we currently have, at least 89 times better than what we have right now, or 87 times.
Mr. Chairman. I'll take your smile as okay to ask a follow-up question. Mr. Ward, kind of following up on the equal protection aspect of this that Senator Limmer asked, I had some of the same concern. Certainly, there are people who are drug or alcohol addicts because they experienced trauma in their lives that were not combat related. And you could posit a hypothetical of a young girl who's raped as a child or sexually assaulted as a child. Parents are abusive and alcoholic, divorce. By the time she's in her teenage years, she's abusing alcohol or drugs and ends up at the same place in terms of conduct behavior as someone you know, who's received the trauma in military service. Yet we don't necessarily have the same wraparound services available to assist that individual when they commit a crime and end up in court. And not all of military trauma is caused by combat either. I mean, I actually have had a client who suffered lifelong alcohol issues, not because he served in combat, but because he was sexually assaulted while on a base in training. And it was traumatic enough. It's haunted him for decades now and has caused repeat concerns. And we were fortunate in that case to have a judge that in a non-metro county that was familiar with the VA and the services available there, and was willing to give him an opportunity to take advantage of those services. But part of the question is how do we turn, I ask this with all sincerity because I don't know trauma in their lives and the way they grew up or their own experiences that are comparable in severity. But when they come into the criminal justice system, they don't get treated the same as this well, as any vets going into current veterans court, let alone how this bill would establish their treatment. How do we handle that?
Mr. Ward.
Mr. Chair, Senator Latz, and I know I don't have an answer to that. I didn't hear all of your question because it blocked out for a second there.
My internet's been a bit unstable.
No worries. I mean,
what's on the user on this one, but that's a whole different story.
Without a doubt, it is a concern that was discussed. I assure you that Mr. Else and the others and who participated, I brought up the same exact concerns that you just brought up. I did. If you go through the layers, though, I mean, realistically, where you are charged, what those county lines now really depend on the sort of rehabilitation and treatment you can get no matter what. Right? Some counties have the resources now and some do not. Some counties have treatment courts now, some do not. What's the fairness in that? And I agree with you. That's an equal protection, a due process issue. That because a county has the resources or the wherewithal or the desire to do something different than we've done 30 years ago and actually apply treatment courts to get to the source of the reasons as to why people are there, and others are doing the same old, that's an issue I have, and that's true throughout this entire state. The reason, again, and I don't want to restate the same obvious thing, but the reason I was convinced that this was the right thing to do, and I have family who have been in combat, and frankly, it messed them up pretty bad. But that wasn't the motivating factor for me. The motivating factor has been just the sheer number of deployments of individuals that was unforeseen. It has never been seen in the history of this country. Getting deployed twice or three times was a big deal in previous wars, but now it's literally in half a dozen or a dozen times. I've read the literature. I've seen the data about the effect that these wars have had on people. And granted, they enlisted, right? We don't have the draft. I get that, but it's a government-sanctioned harm. This bill does provide for someone who's been sexually assaulted on the base and suffers from trauma. We did incorporate that and other traumatic events as a part of being a person in the armed forces. But these are the folks who, provide us the ability to have this conversation we're having now. We have a democracy or a republic. Provide us with the ability to be safe from other countries. We can argue over the politics as to why we are where we've been, but the bottom line is that's where we're at. And we're asking our National Guard to be deployed over and over. I mean, in your lifetime, did you ever see the National Guard being deployed this much on wars overseas? Never. So that's why I made the determination, although it is contrary to who I am as an individual, not just as a state public defender. This is the right thing to do for these folks. It just is. We put them in that place, and we need to do the right thing to stand by them when they come back here and they're suffering and they are alleged to have committed a crime.
So, Mr. Ward, again, I wanted to remind you that I think we're all agreeing on the goal. We're just trying to figure out how to do it. Senator Latz, did you have follow-up?
Yeah, thank you, Mr. Chairman. I think part of this just illustrates perhaps the need to, the simple answer would be to make sure we have the resources to expand treatment courts and veterans courts to everywhere in the state. That might almost treat this as a pilot project for how to approach, some changing some of the rules or expanding some of the rules for the veterans courts themselves. But, 90% of the people in our prisons have some sort of mental health or chemical dependency problem. We just had a bill on traumatic brain injury, which essentially has the same goal as this bill does. Just sort of a different, more physiological cause, perhaps. Although you have people come back from combat with TBI as well because of what they've gone through. If the sort of restorative justice model is one which we would probably do well to expand throughout our judicial system and use more frequently than we do generally. And there's a substantial resource element to that, but it might save a substantial amount resources down the road in terms of reducing recidivism, reducing the number of victims of crimes, as well as saving, literally in some cases, saving the lives of people who go through the criminal justice system also. I'd be curious to know if anyone can even answer the question, since Hennepin County went to a stay of adjudication model, which leaves the case open and being adjudicated potentially. So then at that point, I suppose the public defender's office would still be involved. Has there been any observable difference in the Hennepin County Veterans Court in terms of the number of veterans interested or willing to go into that Veterans Court process, or the number of veterans that are successfully completing the program when they get to the end of it? I mean, it may be too early to have data on that, but maybe even anecdotally.
Judge Meyer, do you have any anecdotal information on that?
Mr. Chair, Senator Latz, I can definitely get the numbers for you. We keep up-to-date numbers on how many participants we have in each of our courts, and I can look at the point when that change occurred and see whether there's been a drop-off in number of participants, and talk to the current sitting Veterans Court judge to ask her if the number, well, actually we keep stats on the number of referrals as well. So I can definitely get that for you. I do not know off the top of my head, however.
Mr. Elf?
As a defense attorney that appears in the Hennepin County Veterans Court pretty frequently, I can tell you there's a lot more people in there in the past. This is now almost 2 years that Hennepin County's been following this model. And then the numbers of veterans that I see in the court has increased a lot. And I know that they were very concerned about the number of participants at the point that which Mr. Freeman adopted this.
So, Mr. Chairman, I would just add, in my own practice, I evaluate everyone who comes in as to whether or not they might benefit from, the DWI court or the Veterans Court. And I've seen Mr. Ellis in the Veterans Court on a number of occasions, and the treatment courts in Hennepin County do a terrific job. I was frustrated at some of the criteria that barred some of my clients from being able to go in to the treatment courts when clearly they needed that level of wraparound services to try to put their own lives back together. But even in all the other regular courts in Hennepin County, at least in my experience elsewhere as well, a lot of offenses are connected to alcohol and drugs, no matter what the offenses are. And the potential penalties for, say, a misdemeanor just aren't severe enough to cause a person to decide they're going to go through all of the work that's involved in a treatment court. They would rather just take the criminal sanction that they get in the regular court and try to move on in other ways, even when one of the conditions of probation is follow the recommendations of a chemical use assessment. So, not everyone needs or would benefit from this level of services, and not everyone would be willing to opt into that because of the imposition on their own daily lives. And where you draw the lines there is hard to figure out too. But certainly there's a greater category of people that do need and would benefit and would opt in to these treatment courts and veterans courts than we currently have the resources available to handle, or the availability of these programs to handle. So I would certainly support the expansion of the availability of these courts and the incentives to enter them and the benefits from successfully completing them. And I'd really like to see the statistics on that as well. But certainly I think this is moving in the right direction. Whether it's ready to become state law is, I think, part of the analysis we're going through in this hearing today. And so I appreciate that. Thank you, Mr. Chairman.
Senator, you're muted.
I'm going to gain a real reputation here. People will start talking. maybe they already have. I wanted to ask a question to counsel. It kind of came up. If the court cannot convict due to the stay of adjudication, can we confirm whether or not that individual can still retain the right to possess firearms? Mr. Backus?
Mr. Chair and members, just to clarify, like the ability of the court to convict, the court does have the ability in the bill to eventually convict if the person violates a term of probation or something like that. But during the pendency, when the person has the stay of adjudication, almost all of our firearms prohibitions or disability laws deal with conviction. So the offender wouldn't be convicted in this case. I imagine in that situation, that since the person is put on probation, that I imagine the judge would have the option, if the judge wanted to perhaps order, not to possess firearms during that period. Maybe that's something someone else would like to jump in on. I don't want to put Judge Meyer on the spot, but I don't know if a judge would be comfortable doing that, but I imagine they would have that authority if they chose, but the automatic provisions wouldn't apply, I wouldn't think, because there's no conviction.
Judge, would you want to make comment on that?
Mr. Chair, I agree with what Mr. Backus just said, which is the lifetime prohibition on firearms possession would not apply because there would not be an adjudication. I am a little unclear legally if it's probation that this bill intends to do the supervision. If there's not a veterans court in place, that's unclear to me. Because I don't know. We don't do stays of adjudication on felonies other than 152-18s, so drug cases. But assuming probation is going to supervise, I believe, and Mr. Ward's welcome to disagree with me, that the court can impose conditions that appear in 609-135 which include firearm non-possession of firearm, ammunition, and explosives during probationary period.
Well, that kind of leads me to another question, and that would be under eligible offenses that are referenced in the bill. What kind of crimes are we talking about? Mr. Ryan or Mr. Warden?
Bill,
Mr. Backus might be better at this. He's got it in front of him. Mr. Backus?
Mr. Chair, members, you should look to lines 1.9 and 1.10, eligible offenses. So it'd be any misdemeanor or gross misdemeanor and any felony that is ranked at severity level 7 or lower or D7 or lower. The bill wouldn't, for the most part, the bill's not intended to apply to predatory offenders, as Mr. Else mentioned, and that can be clarified in a subsequent amendment. But it would apply. It would apply to any, as long as the judge makes the determination, it would apply to any of those offenses. I'm sorry.
So, Mr. Backus, does it include violent offenses? Violent crime?
Mr. Chair, members, you'd have to just look through the rankings of the crimes. It would include DWIs. It would include assaults. Certainly domestic assaults, fifth-degree assaults. It would include things like aggravated robbery, second-degree assault. Just anything ranked below that on the guidelines grid.
So it would include weapon-related crimes?
Mr. Chair, members, I'd have to double check to see where they're ranked on the guidelines, but I would think it would. It would include anything unless it's ranked at severity level 8 or above, essentially.
Right. I haven't heard from Mr. Fournette. Mr. Fournette, would you want to unmute? Thank you.
Thank you, Mr. Chair. That's pretty accurate, Your Honor. Some weapon charges would be included in that. I think Mr. Ward said it earlier, and he's completely accurate. Let's take a hypothetical where a veteran gets in trouble and he commits a level or severity level 7 crime. It's his first offense. he'd be given a stayed sentence anyway and placed on probation, likely under the same type of conditions that he would be if he was given a stay of adjudication. He'd be supervised. So I think when you look at it from that perspective, a lot of these crimes that are in this category, you're looking at a stayed sentence as opposed to a stay of adjudication. What it would be is possibly a stay of imposition of the sentence or stay in the execution of it. So the severity level, I get that some of the crimes in there, like an assault crime, it is a crime of violence, but I do want to kind of point out that they are crimes that don't necessarily mean you're going to be a presumptive commit to prison anyway. Also, in some of these crimes, lower level crimes, Your Honor, a lot of times a prosecutor has discretion to give a stay of adjudication, but there are some crimes in there, Your Honor. But when you're talking, I think like Mr. Beck has said, you're talking about your aggravated robberies or offenses where substantial bodily harm is done, or great bodily harm. Those aren't included in here.
Thank you, Mr. Fournette. And you don't have to call me Your Honor.
It's a habit. It's a habit, Mr.
I know.
Chairman.
We catch them all the time. Mr. Backus, did you have anything to add?
Yeah, Mr. Chair, as we've been discussing, it is going to depend on where the offense is ranked on the sentencing guidelines. And I think the intent of the bill, I don't know this. I haven't talked to Mr. Else or other people specifically, but I assume the intent of targeting level 7 and lower is because that is a stayed sentence at 0 points. However, there are, and I'm sorry, the prosecutor is correct, of course, that if it's 0 points, it would be a presumptive stayed sentence. But depending on the offender's criminal history, that could become a presumptive prison sentence, depending on the criminal history, even for, D7s and D6s, et cetera.
Well, Mr. Backus, well, now that you brought it up, is criminal history taken into account?
Mr. Chair, members, no. It's taken into account in the sense that if there's a provision in the bill that would say if an offender has received a stay in the past under the bill for a felony offense, that instead of being mandatory, it would become permissive. But for everyone else, the way I read it, the offender's criminal history is not relevant.
Could it be? Should the criminal history be relevant? Getting crickets here. Judge Meyer?
Mr. Chair, thank you. As I read this, I read it as this is the first time, your first case like this, you would come in, it's a shall, and you can show that the crime was connected to your service-related issue. It's a shall. But then subdivision 4, which is one of the things I pointed out, it's great, right? You're specifically going to say that your service and your applicable conditions are things the judge should consider in determining whether to give a dispositional, and I believe it said, or durational departure. So that basically, if you get into the boxes where the presumption is prison commit, that we would consider these things and be able to rely on them in determining a departure.
Thank you.
Mr. Chair?
Mr. Backus.
I think, I think the bill has a number of components to it. And, I think subdivision 2 is entitled deferred prosecution. That's essentially the initial stay of adjudication. Under that, if the judge makes the requisite determination, i.e. that it's an eligible offense, that the offender has an applicable condition that was caused by military service, et cetera, the judge would stay the offense, stay the adjudication, and put the person on probation. Subdivision 3 deals with the actual discharge and dismissal down the road and whether the guy would get the guilty verdict actually entered. And there is some language in there. At that point, I just should point out that safety to the public is relevant there, for the actual discharge and dismissal down the road, but not for the initial stay of adjudication. Then we do have that subdivision 4, which is something that I've been working with Mr. Ellis and other people on. I think the intent is a little different than is actually expressed in that subdivision, but that is intended to be a completely different determination. That's intended to be something permissive for the judge, for essentially for people who aren't getting the stay, if I remember correctly. So that's kind of an independent subdivision, really. At least that's how it was intended. I don't know if that's confusing people further, but that's hopefully that gives a little bit more clarity.
Thank you. Sarah Kimpmeyer, sorry to keep you waiting.
Oh, my goodness sakes, Mr. Chair, no problem whatsoever. Just a fascinating discussion. My name was used a little bit ago, and I was kind of surprised by it because in my introduction remark to my question, I think I was quite clear in regards to understanding the goal and supporting the goal and things like that. Asking questions here was to clarify and help make sure that it is implementable, not just that we vote for the idea. And I'm encouraged by this discussion. I think getting down into the practical things and asking these questions is the job of judiciary, and doing a good job of that is the hallmark of this committee. But Mr. Chair, are you intending to lay this over, or shall I?
Well, it's not really before us right now, or this is an informational hearing. I would want to continue to, for lack of a better term, lay it over. I'm hoping that the proponents and the judicial partners would be involved in this. And I think between both systems, I think at least this airing has given us a little bit more understanding of where the bill might be going, or not the bill, the concept, and that hopefully we could come back next year with a finally polished program that the Judicial Concept Council could fully embrace, and that we would have a united mind on the direction we're going. I am troubled by giving dictate to the third branch of government. And I would hope that we could resolve this and going in that direction without going to that, what I would consider avoiding judicial discretion. So I do know that this program is rather prescriptive, but it does raise questions about judicial resources, judicial process, judicial administration. And so those are questions that I think are still need a little bit more meat to the bone to be placed on it. Senator Chamberlain.
Yes, before we are finished with this, or after we're done, could I ask council or staff to be sure to provide us with a list of actionable items so we can act on those items and then take care of them?
We can ask council to do that.
Yeah, we have a list of actionable items, Mr. Chair. We can address that, but right now it's been kind of difficult to follow. Thank you.
Mr. Chair?
Yes, Mr. Beckles.
I guess I would, I don't know. I don't know if I could provide that. I think the list would be whatever the members would want to address. I mean, I could assist and I would work with whomever wants to work with me. I don't know that I would be the one to present that type of list, though.
All right. Senator Chamberlain, I think we can get you a list by reviewing many of our notes. At this point, for lack of a better term, this bill is laid over. I want to thank everyone for the participation. It has answered a number of my questions. It may have raised some issues as well. I think this is a worthy goal to pursue. And I hope that we do, I can tell by the passion in the discussion that this is something that will eventually take place. But for now, it's in abeyance, and we will continue working on it. I hope over the interim that both proponents and those that are in the administration, if I can give a signal out to the administration that this is something that we should pursue. Resources are something that I will have to pursue with Mr. Turner and others as we progress. I think that's a major issue as well. But Senator Latz, any closing comments regarding this?
Mr. Chairman, we still have over 2 months left in the legislative session. And so I suspect it may be possible for those who are interested in doing so to pull together some of the information and stakeholders, and maybe we can see something that we can return to yet this legislative session. That would be my hope anyway.
Yeah. And hopefully, Senator Latz, we can get focused back on probably the number one priority, and that's the budget that we have to build and present and wrestle with the House on. So,
Mr. Chairman, on another topic, if I may, if you're done with this.
Yep. Go ahead.
It's now 20 to 2 on a Friday. I know a lot of us typically set aside the entire days on deadline days to hear bills. I know that there are a lot of bills in the pipeline. I've got well over half a dozen anyway of my own. I know other members of the committee and including those on my side of the aisle have been waiting to get hearing notices for some of our bills that are consensus bipartisan bills that are non-controversial. And I would hope that we could have had more than 4 bills on today's agenda for consideration. Certainly, we've had the time to be able to do that. And I, for one, am willing to put in extra time in the next week also to get bills through, not entirely rely on the House to throw bills into their budget bill and hope that I don't think we're going to be in a position, having not used all of our available time, to be able to legitimately claim that we didn't have time to hear all the bills that the House wants to hear and then claim that we can't accept them because we didn't hear them on the Senate side. It doesn't become a legitimate explanation for refusing to accept bills in the House proposal when we haven't used all of the time that we have available to us to hear the bills. So I'm hopeful that we can look at the bills that have merit, that have consensus on their merits, and we just go ahead and do the good public policy thing that we need to do to get them passed without perhaps any further delay or barriers, just because that's what we do. We should be doing anyway, is looking at bills that everyone seems to agree on and don't seem to have any controversy, that everyone agrees is good government and should go ahead and get done, where the stakeholders have the peace in the valley, if you will, and we could just move them because they're the right thing to do, and maybe not think, not worry so much about the other elements of decision making, since we clearly have had some of the time to do that. I think we should utilize our time. So I make that request of the chairman to fit more of these bills in. Thank you.
Thank you, Senator Latz. One of the things that I mentioned before was that 2/3 of our bills came almost all at the same time. That was a result of the backup in the revisor's office. Most of them came just in the last 2 to 3 weeks. It's been rather difficult to manage the volume all at that short period of time. I think everyone should know that quantity is not necessarily my primary focus. Quality and comprehension of the proposals before us is. But we're doing our best, and we'll do our best to get through all of this in the upcoming weeks. I appreciate your patience on that, and it's about the best we can do right now. I see that Senator Chamberlain is trying to get our attention. Senator Chamberlain?
Thank you, Mr. Chair. I'm a little confused. Were you done with us?
Yes.
Thought?
Well, in a manner of speaking, we're done with you. Hopefully the bill is not done with. I hope that we've raised some issues. We've taken a perspective from kind of a high elevation looking down at your bill. I think it's raised some issues, some concern. And I would say that the bill probably needs a little bit more work and collusion with other partners. So I would say keep working on it. I think it's a worthy goal.
Thank you, Mr. Chair, members. It's been instructive and helpful. Thank you very much. Have a great, blessed weekend.
Thank you all. Senator Latz, further discussion? All right. No further business before the committee. We stand adjourned. Thank you all.